It's been pushed for the last 3 years. Oh,
Mr. Brown, please mute your device until the case is called.
yes, Ms. Moore.
Good afternoon, Judge. Is there any chance that I could be put in a breakout room with all of the witnesses for the trial? I believe we should be ready to get started within the next few minutes.
Who are your witnesses?
I believe I have Detective Carmona, Samantha Kellogg should hopefully be on here. Perfect, okay. And Corporal Millisor, if possible.
Oh, wait, I'm sorry. Millisor?
I believe he's listed under
Thank
iPhone.
you.
Thank you.
And then the middle one, Taplin, as well.
I know, I'm sorry. I was like, yeah.
Ms. Moore, I'm sending you the number 2 with those people that you named.
The attorney's on the way. She said she was being held hostage at these recordings. Shouldn't be too long. That's the second part of the first.
Mm-hmm.
There's nobody else here. So.
Why would we be on time?
Okay, I'll let you know.
Ms. Taplin,
Yes.
what are you here for, ma'am?
Your Honor, she's a witness. She's the lab tech. You may want to throw her in for the chain of custody for the blood.
I'm sorry, I didn't think that I heard Ms. Moore name her.
She probably wasn't aware, Your Honor.
Okay, thank you. Ms. Taplin, I've sent you an invitation to join the prosecutor.
It's one of those days.
Ms. Belcher, it's been a perfect day, actually. I've entertained and I've been entertained, so.
This is true. This is true.
How can I not be patient? I'm here until 4 o'clock. I won't get worried until 4:30.
So I should call off some of my 20 witnesses. That's going to keep us here until 6:30.
I'm happy to stay if you'll assume the cost of overtime.
I was gonna say, it was weird to have you say the file will go down to probation, just made me think you brought that memory, like, okay, you know, just follow that file of probation.
I do want to send it down to probation because I don't know what is next. I don't know if there is some input from somewhere else. And when you have a plea without any kind of proposed or recommended sentencing, I'm not going to guess.
Yeah, yep.
There are people for that.
But, so is probation letting, are they having people go down there and talk to them yet?
I don't know if they are or if they're using the computers out front. Okay. So, is this Leanna Belcher? The next time she's here, I'm gonna have to show her. We're gonna have to have a talk.
That's-
What's wrong?
Nothing.
it kind of-
I love seeing you in the morning on the docket. I know it's gonna be efficient. You're helping people who don't know how to get out of their own way.
Well, thank you, Judge. I appreciate that. It's always a pleasure being in front of you.
Because, oh, thank you. Because when I say we have court-appointed attorney here for you, you should avail yourself of them. No, I'm good. No, you're not. Please. I need you to go into this room and talk to this attorney who's gone to school and taken these tests. And I understand that you might not be incarcerated on this charge, but there are ramifications to you pleading when all you have to do is present the certificate. Why would you take a misdemeanor if you didn't have to? We're not about punishment. We're about keeping you from doing the same thing again.
Agreed. And I think it's very kind of you to not just take the plea to move the file and you kind of direct them in the direction they should be going in.
I think that we get a bad rap. I think that people are under the impression that we are part of some bigger machine, and we're not. We have all agreed to live by certain rules. And when you violate those rules, there has to be some consequence. The consequence shouldn't be a fine or imprisonment when that's not really what's going to stop you from doing the same thing or breaking our agreed upon rules again. It doesn't help. It hasn't helped in the past. It's not going to help now.
Agreed.
I'm lecturing to the wrong person. It's like when I talk landlord tenant stuff with landlord tenant attorneys. I'm like, we have to agree that there are certain things we do to be in a civilized society. There's certain rules we have, there's certain things we agree to, and you know. But no, I got worried at 10 o'clock. I looked up and there were too many people on the screen. There were too many people in the waiting room. And then all of a sudden it just evened out.
I think it went very smooth today.
I get nervous when the docket's 4.5 pages long.
Yeah. Yeah. I see why. That's a long docket.
Well, I don't like people to feel rushed either because
Right.
it is a new process for them. And if this is your only time in your life in court, you don't know what you're doing, how to connect, you can't hear, you can't see, you're not sure what the next step is and what the magic words are.
By chance, Judge, did Mr. Brown sign back into Zoom?
No.
Okay. And full transparency, he was having some technical issues, which I know Your Honor was nervous about when we set this for the Zoom bench trial. So I've been trying to walk him through the issues that he's having. Hopefully that will not prevent us from moving forward.
I think we're all trying to figure it out. And sometimes technology gets in the way of people who've been able to Zoom in before. So we'll just be patient. There's nothing. The next thing isn't scheduled until 1 o'clock. We'll get done what we can get done.
Okay, thank you, Judge.
You're welcome.
I thought it was really funny when you said, we're on that page too. I was like, "Please," right when you said that, I was thinking.
Well, because when I first came out, there were just attorneys, which made me nervous.
Mhm.
And then the jail came, and then people came, and I saw them, and I couldn't get to them. And I want to at least acknowledge them so that they know I see you, and I'll get to you in a second.
Right.
I'm not ignoring you. I just am trying to get through the fast stuff so that we can have the time. Or you had attorneys that were covering for other attorneys, which I don't see you on the list. What are you here for?
Right.
Don't give me this. I'm here for this. Just give me the short version. I'm here for this thing. And these attorneys that check in, who put their name and their client's name in the chat box, I love it. And they're on the roof. That is scary. Were you kicked out? Did you need more time?
If I could have 2 more minutes, that would be great. Otherwise, we can get started.
Real 2 minutes or attorney 2 minutes? Let's see.
You know what? Let's call it a real 3 minutes, and then we'll be good to go.
I'm gonna give you as much time as I would want if I were you. So everybody can rejoin number 2 with Ms.
Thank
Moore. I love attorney 2 minutes.
You know, I wonder what happens when they go in and then it automatically popped out.
They weren't, they were in there for 10 minutes.
No, I'm just saying like when it happens to me, when I put them in.
Because the time isn't reset, so they just have the remainder of the time that was on there. It doesn't reset when they re-enter, or when they go in.
Is there a way that I can do that? Or can I change that every time?
You could, but then you'd be forever resetting. You'd be forever in the options to reset. I like Zoom, but I'm missing people.
Oh, gosh, yeah.
It's fine for fast things like today. You know, for PCCs, it's quick to either adjourn or we need discovery or da 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 da. I think trial, it gets iffy. That was the same conversation I had with who yesterday? Steve Robinson, I think.
Yeah.
And as an attorney, you're doing a trial and you want to bring this big piece of evidence. You can slam it down so people can see it and it loses its allure
Oh, yeah.
on the screen.
Or how about like when we used to be able to hang up on somebody? No, you can't. Or like when you're mad. You can't do it.
I know you're just like, hello, hello, hello. I think I dropped the call. So I leave and I think I'm gonna go sit down and sign these papers and I look out and I see a truck outside. So I'm like, hey, are you just gonna leave? You're not gonna come down and say hello?
Oh, was it, Josh?
That's how he wound up down here.
You're so darn cute.
I said, wait a minute, what are you doing here? B, don't come in this building, don't come down here, at least say hello.
I'm gonna go grab that file, maybe you can run.
Tennille?
Is it
Yep,
under-
it's in the basket, rubber band with a note that says Mackenzie.
In your office?
Nope,
Oh,
in
right
this,
up here.
yep.
Oh, okay.
Want it out here?
Yep.
Did you have this as a voicemail?
Yes. Well, no, yes, he called Marlisa, spoke to Marlisa, and then Marlisa passed it to me. Are you gonna call?
Nope.
Oh.
I was gonna call and get the adjournment date, and then I realized that I still had my paper out here.
You found your piece of paper?
No, I didn't find the real one, I found the fake one. Uh. Hmm.
It looks so pretty out with those little puffy clouds just floating by.
Yeah. Thank you, ma'am.
Do you have that little piece of paper that I gave you? I'll call him. Thank
Let
you.
him know, thank you. Ms. Belcher, Mr. Brown is back.
Your Honor. Mr. Brown, can you hear me okay? Pardon me? Okay. Will you just mute your device until the case is called? We're waiting for the prosecution.
We are the people on there for the Zoom trial or whatever.
Yes.
Do you want to do that one?
I'm trying to. No, you're fine. Ms. Moore is in the video, is in the breakout room with them.
Did you need the prosecutor in here? I'll get him in here.
Ms. Moore is on that file. She's in the, Ms. Moore is in the breakout room with the witnesses.
Okay. Our other attorney has not showed up yet, so. It's not that far of a drive from Inkster.
Depends on how you drive. And did you get on 275 and where does the backup start now versus
Oh,
if
it
you're not
ends,
familiar with the area?
if you're coming north, I think it ends at 94.
She's coming south. She's coming from Inkster.
Right, so she shouldn't hit it at all.
Because it started, well, you know what? Yep, it started right after the 94 connector.
Hmm.
I wouldn't come that way, but like I said, if you're not familiar with it, is that Mike Long? No.
Because it's the fire department. So we called Al and said, Al, is there something you should know?
Yes, ma'am.
Judge, thank you for the extra time. The people are prepared to proceed. I just want to jump to the room right next to me so that if APA Alex Curry needs to come into this room, he's not interrupting.
Okay. So she said 3 minutes, and so I asked her real 3 minutes or attorney 3 minutes. So
You're
they
correct,
were
Judge. I apologize.
Attorney 3 minutes. Ms. Moore, I'm just giving you a hard time. No.
Where you at?
No way. Why? No. You can go out in the hallway and be menacing.
Anyway, the fire department was Honeywell needed to spray water up on the roof or something to do with the heating and cooling. They had no source of water, so they called the fire department and tied up a hose and sent it up there.
Oh, they did not.
Mhm.
We didn't even.
I said to Jamie, I said, hey, Mr. Building Maintenance. I said,
Hey,
"Fire
put a
department."
pin in that for 1 second. 210019 ST. This is State of Michigan versus Mark Anthony Brown. Appearances, please.
Good afternoon, Your Honor. May it please the court, Leanna Belcher, P80177, on behalf of Mr. Mark Brown, who's present via Zoom. Mr. Brown, please unmute your device and state your name for the judge. You have to unmute first, sir.
Can you hear me now?
Yes, state your name, Mr. Brown.
I'm sorry, Ms. Belcher, hold on for 1 second. APA Moore told me she was going next door, and I assumed next door she wasn't on when I called the case. Ms. Moore, my apologies. I need Alex Curry. Yeah, because I don't know, but I'll fix it when it comes back in. I'm sorry, Ms. Moore, I called the case, and Ms. Belcher was putting her appearance on.
Good afternoon, Your Honor. Elizabeth Moore on behalf of the people, P84724.
And Leanna Belcher again on behalf of Mr. Mark Brown. Mr. Mark Brown, state your name, please.
Mark Anthony Brown.
Thank you. Today is the day and time set for the Zoom bench trial in this matter. Are the parties ready to proceed?
Your Honor, at this time, the people are prepared to proceed.
The defense is ready, Your Honor, and I would just make a motion for a mutual order of sequestration.
I join in that mutual order of sequestration. I do ask for an exception for my officer in charge, Detective John Carmona, who at this time I do not intend to call at the trial. However, should it become necessary, then I will be calling him.
No objection.
So who is going back into the waiting room? I'm sorry, motion granted.
I ask that it be Shanique Taplin and forensic scientist Samantha Kellogg.
I'm putting them back into the waiting room until you need them. If there are any other persons who could potentially be witnesses in this matter who might be viewing the matter on YouTube, I would ask that you immediately stop viewing the matter. Any other preliminary matters, Ms. Moore?
Yes, Your Honor. Unfortunately, I do have preliminary matters in this case, and I will indicate that I will ask for this at the conclusion of the trial.
I'm sorry, Ms. Moore, if you could stop. One of your witnesses is still on the screen. That's Ms.
No, that's me. She raised her hand and I put her out. Thank you, Ms. Belcher.
The preliminary matter in this case, I do believe that count 1, operating while intoxicated, is correct. However, I will be changing the specifics of it as the actual charge is incorrect. Currently, it says did operate a vehicle upon a highway while having an alcohol content of 0.08 grams or more. I move to amend that, should the testimony support it, to operating while under the influence of a controlled substance. That is as it relates to count 1, and I have a proposed amendment to count 2 as well. And I apologize.
Your proposed amendment to count 2?
My proposed amendment to count 2 is driving while license not valid instead of operating while license suspended, revoked, or denied.
Ms. Belcher, your response to these 2 requested amendments?
Your Honor, while I feel that they are very untimely on the eve of trial while we are about to begin, I cannot fault Ms. Moore for that. I understand that she's taking over this file today. I would just note for the record that the defense's position is that this is untimely.
I'll note your objection, Ms. Belcher. The motion is granted. Ms. Moore, give me one moment. Ms. Moore, are there any other preliminary matters?
No, Your Honor, there are no other preliminary matters.
Ms. Belcher, any preliminary matters for you?
No, not on behalf of defense, Your Honor.
Your first witness, Ms. Moore.
Thank you, Your Honor. At this time, the people call Corporal Scott Millisor.
Your Honor, I believe that's the incorrect witness.
I'm sorry?
I do not believe the witness presented is the one that Ms. Moore intended to call at this time.
No, Your Honor.
Should say iPhone.
It did, and I thought that's who was admitted. Second try. Okay. Good afternoon, sir.
Hello.
Please spell your name, state and spell your name for the record.
Corporal Scott Millisor. Millisor.
Would you raise your right hand? Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Thank you. Ms. Moore.
Thank you, Your Honor. Please restate your name for the record, sir.
Your Honor, I'm sorry. I would just ask that the witness remain visible at all times throughout his testimony. His screen went blank.
Yes, ma'am.
I apologize.
Sir, please restate your name for the record.
Corporal Scott Millisor.
Are you currently employed?
Yes.
Where are you employed?
Detroit Metro Airport Police.
How long have you been with Detroit Metro Airport Police?
20 years.
Were you working as your duties on November 3rd of 2019?
I was.
What was your rank at that time?
I was a corporal.
And how were you dressed on that day?
I was in full police uniform.
Were you on foot or in a vehicle?
I was in a vehicle
How was your vehicle marked?
with police markings and overhead lights.
Were you working alone or with a partner on that day?
I was alone.
Did your duties as an officer take you to at or near the location of the Detroit Metro Airport?
I did.
Is that located in the city of Romulus, County of Wayne?
Yes.
Why were you at that location on that day?
That was my assigned work area.
Were you specifically assigned to the north departures area near door number 1?
That was my area. Yes.
Did something occur at that day and near that location that brings you to court today?
I conducted a traffic stop that resulted in a OUID arrest.
Do you recall what type of vehicle you conducted a traffic stop on?
I believe it was a Grand Marquis. I'm not sure of the color.
And what initially drew your attention to that Grand Marquis?
The plate was expired initially, and I ran the plate through SOS and lien, and the plate came back not valid for insurance purposes, fraudulent.
After it came back not valid, what, if anything, did you do next?
I'm sorry.
After it came back not valid, what, if anything, did you
Sorry.
do next?
Ms. Moore, it appears my client is off the screen.
Perhaps we should wait a moment for your client to come back on.
I would appreciate that. I'm sorry, Your Honor. And if this continues, I have no objection to Your Honor scheduling this for in person. I understand that the court's time is valuable and I do not want to waste any of it.
I appreciate that, Ms. Belcher. I'm watching our waiting room to see if your client reappears. Or waiting for something.
We were waiting already. I'm Kirschner. What did anybody say?
Okay.
And then the 12 o'clock attorney's talking to our client.
Mr. Vincent's here.
I'm sorry.
Mr. Vincent's here.
On the OWI.
Yeah.
It's a woman. Kirschner.
Yeah.
Oh,
But no, Klusner.
Kuzner.
Klusner. Oh, I said, no, it's Vincent. Murray Duncan.
Yes, he's here.
Have them come in.
Okay.
Hello again,
Ms.
sir.
Belcher, if I could just direct your attention, I'm going to send you a chat.
Sure thing. Thank you.
Mr. Curry, if you would be so kind.
Yes, ma'am.
Oh, he's back.
I have to give me just
Not you.
take it. Sorry.
Would you please? Mr. Duncan wasn't walking in yet. Mr. Brown is back. We can resume questioning of Corporal Milsor.
Thank you, Judge. Corporal Millisor, you indicated that you were effectuating a traffic stop, correct?
Correct.
Now, after initiating that traffic stop, did you approach the vehicle?
I did.
Your Honor, I would object to leading questions by Ms. Moore. I would ask that she rephrase her questions in a way that are not suggestive of an answer.
Your Honor, I don't believe that that did suggest an answer. However, I'm happy to rephrase.
Thank you, ma'am.
After conducting the traffic stop, what, if anything, did you do next?
I approached the driver's side of the vehicle, asked the driver for his license, registration, insurance.
You indicated a driver. Were there any other occupants in the vehicle?
If I remember, it was a while. I know there was a child, and I believe there was possibly one other adult. I'm not real confident on that, though. But I'm confident there was a child in the car as well, along with the driver.
You indicated you had contact with the driver. What specifically did you ask of the driver?
I asked for his license originally and his insurance, and then while speaking with him, that's when I smelled a strong odor of burnt marijuana coming from the car.
Corporal, I'm going to back you up and walk through that step by step. When you approached the driver, would you recognize that driver if you saw them today?
Yes.
Do you in fact see them today?
I don't see anything. My screen's black. I just see you.
I believe if you tap your screen, you can change it to a gallery view. It shows you everyone who may be appearing via Zoom today.
Okay, I see it. Yeah, I do. He's in the white, kind of looks like a tank top.
I'll let the record reflect the witness has identified the defendant, Mark Anthony Brown.
Yes, ma'am.
You indicated a moment ago that you asked him for his license and registration. Did he produce any documents?
I don't recall if he handed me his insurance or not. I know he didn't have a license as well either.
Did he hand you any documents?
I don't believe he did. I feel like, again, it was 3 years. I can't recall on that.
But it's your testimony today that he did not produce a license.
From what I remember, no.
And a moment ago, you indicated that you could smell something coming from the car. What exactly did you believe you were smelling?
It smelled like burnt marijuana.
Have you smelled burnt marijuana in the past?
Several times, yes.
Was that consistent or inconsistent with what you were smelling on that day?
It was consistent what I was smelling.
After you made that observation, what, if anything, did you do next?
I asked the individual if he smoked marijuana, and then he told me he did earlier in the day.
Did you notice anything about the defendant's person or body at that time?
I did notice his eyes were real red, and if I do recall, I believe his pupils were a little bit dilated.
What, if anything, did you do next?
I asked him to step out to speak to me because I didn't want to speak to him in front of the child about what was going on. So I asked him to step out, and he consented to step out. No issues.
Did you walk in any direction with him?
We walked back to towards the back of my patrol car, and I spoke to him like just back by his rear quarter panel, right there by his trunk.
What did you speak to him about?
About more of the smoking of the marijuana, and then I asked him if I could run him through some sobriety tests to see if he was safe to drive a motor vehicle.
After you asked him that, did he provide a response?
He consented. He said he had no problems doing the standard field sobriety test.
Corporal, have you conducted standard field sobriety tests in the past?
I have, yes.
What is a general overview of the procedure that you follow for standard field sobriety tests?
Normally, before we start, we do a 15-minute observation period. So I would notify our dispatch to start that, and it kind of gives us 15 minutes to observe that, there's nothing put in his mouth, anything like that.
Did you do that in this case?
I did, yes.
Do you recall approximately what time you started that 15-minute observation period?
I don't know the exact time offhand, and again, it was almost 3 years ago.
How do you conduct that 15-minute period?
I do it through dispatch, and they're the one that alerts me when the 15 minutes is up.
Is that what you did on this particular day?
Yes.
At some point after 15 minutes, did dispatch inform you?
They did, yes.
After dispatch informed you 15 minutes were up, what, if anything, did you do next?
I conduct while the 15 minutes was going on. I actually started the test prior to the 15 minutes being up. I basically started with the walk and turn. Actually, I started with the HGN, the horizontal gaze nystagmus, where I checked his eyes.
And actually, I'm going to back you up for 1 second. Do you recall if it was light or dark outside?
It was daylight.
Do you recall any details about the weather or the surface?
I believe it was dry. The surface was dry and flat.
Oh. Would you have noted that in your report?
I would have, yes.
Why would you have noted that in your report?
Just because if the surface was not dry, obviously it would affect some kind of how he's taking his test. It could affect your balance, could do a lot of things.
And in addition to that, do you conduct any pre-testing questions?
For each standard field, there is a pre-questionnaire for like medical reasons.
Do you know why that is?
Because if he has issues, then we don't do that test. We move forward.
So given the general time and conditions of the environment, did anything indicate to you that it would not make sense to move forward with the standard field sobriety test?
No.
A moment ago, you indicated that you started with the HGN. What is an HGN?
The horizontal gaze nystagmus.
Please describe how you conduct that test.
We basically start with, we just check his eyes. Basically, I start asking him if he has any closed head injuries, which he said no. If he's wearing any contact lenses, I believe he was not at the time. If he was nearsighted, farsighted. I use a blue pen with a light on the tip. I ask him to reach up, touch it, and make sure he can see the blue pen. Then I ask him to basically follow the blue pen with his eyes and his eyes only, doing several passes, looking for nystagmus in each eye.
And did you ask him to do each one of these steps?
I did, yes.
Did he comply with each one of these steps?
He did.
Were you evaluating his behavior at that time?
I was.
How did he perform on that test?
There was no nystagmus present in any of the HGNs that I performed on him. There was none present.
Did that indicate anything to you?
Basically, when marijuana is present, usually you won't show nystagmus, as opposed to like your alcohol and other drugs taken.
After the horizontal gaze nystagmus, did you move on to another test?
We went to the walk and turn right after that.
What is the walk and turn test, Corporal?
It's where you take nine heel to toe steps down the line, turn and come back 9 heel to toe steps back.
How did you administer, or I apologize, did you administer this test to Mark Brown?
I did. I went through the medical questions as well, asked him if he had any physical injury. He did tell me he had a sore knee, but he still said he was able to complete the test.
After he indicated that to you, what happened next?
I explained the instructions of the test to him. He understood the instructions, and we performed the test.
Did you evaluate him while he performed the test?
I did, yes.
What, if anything, did you observe?
I observed that he missed heel to toe on several steps. I believe he didn't count out loud. I think he raised his arms more than 6 inches to balance. And I believe he had an improper turn on the coming back down on the 9 steps.
What, if anything, did that indicate to you?
Just indicated there was some clues that possible impairment.
Did you conduct any other tests?
We went to the one leg stand.
What is the one leg stand?
Again, it's a where we stand on one leg of his choosing. We lift our foot 6 inches off the ground. The foot is parallel to the ground, and you watch your foot, keep your arms to your side, and you count out loud 1001 and so on until you're told to stop.
Did you demonstrate this for the defendant?
I did demonstrate the test.
Did he complete this test?
He completed the test, yes.
Did you evaluate him while he completed the test?
I did.
And what, if anything, did you observe?
If I remember correctly, on the one leg stand, I believe his count was off, I believe. And I believe there was some swaying that took place on that. And I think he put his foot down as well, if I remember.
What, if anything, did that indicate to you?
Again, that just shows possible signs of impairment.
Was the test over, or did you move on to another?
We went on to another test after that. We went to it's called the finger to nose test.
What is the finger to nose test?
It's where you tilt your head back, keep your arms out to your side, with your index fingers pointed outward, shut your eyes, and then when directed, you bring your whatever hand directed up, touch the tip of the finger to the tip of your nose, and then bring your hand right back down to your side until instructed.
Did he complete this test?
He completed the test, but he left his eyes open for majority of the test, so it's kind of null and void on that.
Why is that null and void?
Because it's when you have your eyes open, it's much easier to touch the tip of your finger to the tip of your nose without, because when you're closing your eyes also, you're also looking for tremors in the eyes and stuff like that. And it's unable to see that when your eyes are open.
Did you ask the defendant to keep his eyes closed?
Well, it was all instructed in the instruction phase. And if he doesn't follow the instructions, that's part of the evaluation.
Did you move on to another test?
We moved on to another test. We did I believe it was the modified Romberg test.
What is the modified Romberg test?
That is where you stand with your feet together, arms down by your side. You tilt your head back a little bit. You close your eyes, and you estimate the passing of 30 seconds in your head. Once you estimate the 30 seconds has passed, you open your eyes and you tell me to stop.
Did you explain these instructions to the defendant?
I did.
Did he complete this test?
If I believe right, he took the test the first time, and I don't think he understood what was going on. So I asked him, do you want to take it again? He said, we did it again. And he estimated a passing, I believe, around 3 to 5 seconds. And then he told me he counted to 27 seconds in his head, and not the 30 that was requested.
During this, did you notice anything about his body?
I believe, again, I believe he had eye tremors and like body tremors from that.
Corporal, what are eye tremors?
When your eyes you're unable to control the muscles in your eyes, and that just kind of shows impairment as well.
Have you received any training on indicators of impairment?
I did take ARID, which is Advanced Roadside Impaired Driving Enforcement.
When did you take AROD?
I believe that was 2018 or 19. The COVID has got me all screwed. So I believe it was 2019, early 2019.
So was that before or after this incident occurred?
Oh, it was way before.
After the modified Romberg test, did you complete any other tests?
I did. I asked him if he could, if he knew his ABCs. He said he did. I asked him if he could recite his ABCs from letter D to R.
And did you confirm what level of education the defendant had?
Yes, he said I believe he said he went to the 9th grade, I believe, but he did say he knew his English alphabet.
You indicated you asked him to recite the alphabet from D to R. Did he complete this?
No. I believe he missed several letters, and then he restarted again and tried it again, and he missed more letters as well, so he did not complete it.
Did you complete any other tests?
We did a number count, which was count backwards from 88 to 66.
Did you explain any instructions to him?
I did explain it, and he said he could count to 100, and he said he was able to count backwards as well.
Did you ask him to count from 88 to 66?
I did.
Did he do that?
No, he missed several numbers.
Okay. Did you conduct any other tests in this case?
I asked, the only thing if I remember asking him if his level of impairment on a scale of 1 to 10, with 10 being the most he's impaired, with 1 being the least. And I believe he said he was a 4 or 5 at that time.
And that was a value that he provided directly to you?
Yes, yes.
After conducting each one of these tests, what, if anything, did the results independently and overall indicate to you?
Well, after that, I gave him a preliminary breath test, a PBT. I read him his rights, and it came back zeros. He had no alcohol in his system. But after that, I did feel that he was under the influence of a narcotic, which was marijuana.
In believing that, what, if anything, did you do next?
I told him he was under arrest, and then I read him his chemical rights test off the back of the DI 177 form, and he consented to get his blood, and then we went to Beaumont Wayne Hospital for a blood draw.
Okay. You indicated that you read him his rights off of a DI 177 form. What is that?
That is the alcohol form that we use. That's his chemical rights test off the back. That's the form we complete when there's any kind of a impairment or OWI involved.
Have you used this form before?
I have, yes.
Is this standard policy in your department?
Yes.
What is included on that DI 177 form?
All his information, our department, the time of the arrest, his driving license status, and a copy is provided to him for his to hold with him for his driver's license.
One moment.
How you doing?
Hold on. I apologize, Your Honor. Another attorney just stepped in. I needed to let him know I was in the middle of a trial.
Understood.
Okay. So you read this form to the defendant. At any point, did you show him the actual piece of paper?
Actually, I gave him a copy of it, yes.
And after reading it to him, did he indicate that he had heard you?
I asked him if he understood these rights. Would he consent to the blood draw, and he did.
After you received consent to the blood draw, what, if anything, did you do next?
I transported him to Beaumont Wayne Hospital for a blood draw.
At this point, do you recall approximately how long it took from when you initially made contact with him to when you were transporting him to Beaumont?
Again, we're going 3 years. I don't really recall that. I'm guessing maybe 40 minutes, maybe, from the total thing. to get to the hospital from after the arrest total.
And you transported, just to be clear, you transported him to the hospital yourself, is that right?
Correct, yes.
Did you eventually arrive at the hospital?
I did.
What happened when you arrived at the hospital?
I informed the staff there that I need to do a blood draw, police blood draw, provided the kit, the phlebotomist came down and proceeded what they did.
Do you recall the name of the phlebotomist?
I don't offhand, I'm sorry.
Would you have included that name in your report?
I would have, yes.
And you indicated that you brought your own kit, is that right?
Yeah, we have our own kit, yes, that's sealed up,
Is that standard policy for your department?
yes.
Now, this phlebotomist, do you recall if they were a man or a woman?
It was a female.
And what exactly did you observe happen?
She opened the kit and drew several vials of blood from the defendant, and then she placed the vials back in the kit and sealed it up.
Were you present in the room the entire time?
I was, yes.
Who else was in the room with you?
I believe myself, the defendant, and I remember the phlebotomist. I don't know if there was another officer. I can't remember.
Were there any other civilians in the room?
I don't think so, no.
After the kit was handed back over to you, what, if anything, did you do with it?
Immediately when I got back to our station, I immediately placed it in the evidence locker.
Is that standard procedure or different from standard procedure?
It's standard procedure. I don't want to walk around with the kit of blood while I'm doing other things, so we just secure it immediately.
Did you also transport the defendant to the station?
I did, yes.
What was your last point of contact with him?
During the booking process, and then we were done.
At any point, did you run his name through Lean?
I believe so, yes.
Okay. Did that show any information about the individual's license or whether or not he had one?
If I remember, I think his license was not valid at all.
One moment, Your Honor. No further questions at this time.
Ms. Belcher, if you give me 1 second, I just want to take this waiver real quick, if I can get Attorney Curry back into the courtroom.
Your Honor, may I use the restroom while you're doing that?
Yes.
Thank you.
210152 FD, State of Michigan versus Nicole Suzette Klusner. Hello.
Good afternoon, Your Honor. Alex Curry on behalf of the people, P84950.
Hello, Judge Murray Duncan, attorney on behalf of the defendant.
Thank you. Today is the day and time set for the live exam in this matter. How are we proceeding?
Judge, I had opportunity to talk to my client at this time. She does wish to waive her right to have the exam and have this matter bound over to Wayne County Circuit Court.
Thank you. Ms. Klusner, you've had sufficient time to talk to Mr. Duncan about your rights in this matter?
Yeah,
You understand that you have an absolute right to have a preliminary examination in this matter,
yeah,
where the prosecutor would have to prove that both a crime had been committed and a probable cause existed to believe you were involved in the commission of that crime.
yeah,
And you still wish to waive your right to have that exam.
yeah,
You have signed a waiver with Mr. Duncan indicating that that is your intent.
yeah,
And you're doing so freely and voluntarily.
yeah.
You haven't been threatened in any way to get you to sign the waiver.
No,
Haven't been promised anything.
no.
Inasmuch as you and your attorney have both signed the waiver, the court will countersign it. The next step in these proceedings are that you will be bound over as previously charged. Your next appearance date will be the arraignment on the information at the Frank Murphy Hall of Justice. We're scheduling that tentatively July 21st, 2021 at 9 a.m. Your bond with any conditions and or limitations will be continued.
Thank you, Judge.
I'll note that there is another matter outstanding in this court that we're waiting for a jury trial date on.
And that's correct, right?
Anything else in this matter, Mr. Curry?
Nothing from the people, Your Honor.
Anything else, Mr. Duncan?
No, Judge.
Thank you for your patience this afternoon. Good luck to you, ma'am. Ms. Belcher,
Yes, Judge.
were you ready? Did you have something?
I'm ready.
I appreciate you allowing me to take that waiver, so you may now begin your questioning of Corporal Milsor.
Thank you, Your Honor. Corporal, I believe you said you've been employed as a police officer for 20 years. Is that correct?
That's correct.
I'm sorry, your audio and video is cutting out a little bit.
That's correct.
Okay. And I believe you initially said what drew your attention to my client's vehicle was an expired plate, correct?
That is correct.
Okay. And at some point when you're conducting the traffic stop, had any time elapsed where the vehicle had gone out of your view?
It is. Yeah.
I'm sorry, Your Honor. I'm having a hard time hearing the witness. If he's
I'm sorry. I was in sorry.
in a
I'm there.
location. Okay.
Sorry, I was in a tunnel. My bad.
No, I understand, sir. Are you able to pull over for the duration of?
Yeah, I'm pulling over right here. Like 2 seconds. I'm pulling over.
Okay, thank you. I'll wait. Let me know when you're stopped and then we can resume.
Yeah, it's just I had to move
Thank
because
you.
I wasn't getting good reception where I was at, so I had to move.
Not a problem. Just let me know when you're stationary.
All right, I'm coming in like 30 seconds. Sorry. Okay, here we go. All right, I'm stopped. Sorry about that.
Not a problem. So your audio cut out a little bit, but if I heard you correctly, there was a point of time where you did lose sight of the vehicle, correct?
Correct, because I think I was down further and then the car went by me. So there was other cars pulling out, so I didn't see it the whole time, no.
Okay, understood. So when you approached the vehicle, though, it was stopped at the airport?
It was, yes.
Thank you. And I believe you said during your conversation with Mr. Brown, you smelled burnt marijuana?
That is correct, yes.
Have you had training to identify the different smells of marijuana?
Through my years of experience, I know the difference between fresh marijuana and burnt marijuana.
But you haven't had any type of training. This is just what you yourself have experienced?
I've just over 20 years of experiencing what burnt marijuana smells like.
Understood. And I want to take your attention now to the field sobriety test that you conducted.
Okay.
How many training classes have you gone to for field sobriety tests?
I think it's every year we get recertified through our department through standard field sobriety. And then I had the additional training of the A-Ride as well.
So if you had to put a number on the amount of training courses you've attended, what would you say?
Maybe 5 or 6, possibly. I mean.
Okay. And you're familiar then with the National Highway Traffic Safety Administration?
Oh, yes, yes.
And are you aware, sir, that only 3 field sobriety tests are validated by the NHTSA and generally admissible in court?
100%, yes.
Okay, and that would be the horizontal gaze nystagmus, the walk and turn, and the one-legged stand?
That is correct, yes.
And I believe the first test that you performed was the HDN, correct?
Correct.
And you stated that you read instructions to my client. Are those instruction cards that you keep with you, or is that something that you recite from memory?
Nope, I read it right off a card. I have a card I keep with me.
Okay, and when you started that test, approximately how far away from my client's face did you hold your pen?
It was between 12 inches, between 12 and 15 inches.
Okay, and which eye did you start on?
I started on his left eye. So it'd be
And
my right.
Sorry, I didn't mean to interrupt you.
Oh, you're okay.
And how many passes did you do, sir?
We do a total of 8.
Okay, are you aware that it's generally recommended by the NHTSA to do 14 passes for this test to be conducted properly?
I was not aware of that.
Okay. And sir, are you aware that there are different neurological, medical, and eye conditions that could cause a deviation of results on field sobriety tests?
I'll take your word for that.
Okay. And when these tests were originally validated, sir, are you aware that they were validated for impairment for substances. They were not originally validated for impairment by substances other than alcohol, meaning that when these tests were originally validated, they were for alcohol consumption.
Again, I'll take your word for that.
Okay, but that has never come up in your training, sir?
Well, yeah, it's come up, but it's never been proven either. So
Okay, but it has been presented in your training that these were originally developed to detect alcohol consumption and not substances, correct?
again, that's correct, but it's not proven.
And when you say it's not proven, I guess I'm confused by that. Are the people that you're receiving the training from, sir, telling you this in your training?
Advanced roadside impaired driving enforcement, correct? Yes.
Okay. And I believe, sir, you stated that you took a kit with you to the hospital for the blood draw.
That is correct, ma'am.
Okay, and the kit was completely sealed?
Yeah, it was sealed.
And did you yourself check the kit?
I did not physically open the kit. The phlebotomist opened the kit. I was standing there when she broke the seal.
Okay. And then after you placed this kit into evidence, do you know what, if anything, happened to the kit?
Personally, I don't take it. I believe our evidence tech takes it and drops it off at the state of Michigan. I believe. I'm not sure their procedure.
Okay, but you yourself did not do anything with the kit once you placed it on evidence?
No, ma'am.
And at any point, sir, did you ever inquire if my client had a medical marijuana card?
I did not.
Okay. I have no further questions, Your Honor.
Thank
you.
you. Any redirect, Ms. Moore?
Yes, Your Honor. Corporal Milsor, a moment ago you were asked about the recommended number of passes for one of the standard field sobriety tests. Do you recall being asked that by defense counsel?
I recall that, yes.
And just to confirm, how many did you complete on that day?
Your Honor, I would object. This has been asked and answered.
Your Honor, I do believe this is clearly within the scope of cross, and I'm just trying to confirm for the record because there were certain numbers that were said by defense counsel. I want to make sure we have accurate testimony.
I believe I did 8 passes.
And you heard defense counsel say the recommendation is to do 14. Is that right?
Correct.
You indicated on direct that you had, within a year of this incident, completed special training, right?
That's right. We researched, yes.
At any point, had you been encouraged to do 14 passes for that test?
I've never done 14 passes, no.
Oh, so still to this day, you have not?
No.
And why is that?
Because I believe the standard is 8, I believe.
So is it your testimony today that your policy indicates 8 passes?
That's what I've always done, yes.
Defense counsel also asked you about the administration of the test for non-alcohol substances. Do you recall those questions?
I do. Yes.
Okay, sorry, I might have had it, might be my connection, that's bad. Do you only complete the standard field sobriety test for alcohol-related matters?
No.
And why is that?
Because there's driving under the influence of drugs as well.
Is there any connection to how people perform a standard field sobriety test and whether or not someone might be under the influence of drugs?
Can you repeat that? I'm sorry.
Is there any connection to the standard field sobriety test and whether or not someone might be under the influence of drugs?
Yes.
In this incident, is there anything that you did that was outside of standard policy for your department?
No.
And if someone were to have shown you a medical marijuana card, would that have changed your decision to conduct a standard field sobriety test?
No, because you're still not allowed to drive while smoking marijuana.
One moment, Your Honor. No further questions at this time.
Your Honor,
Thank you.
I have a couple of quick follow-up questions, if that's okay.
Yes, ma'am.
Officer, I just wanted to ask you really quickly, when you just made the statement, no, you're not allowed to operate while smoking marijuana, I just want to be very clear. You did not find my client smoking in the car at any time during your interaction with him, correct?
That is correct, ma'am.
Okay, no further questions, Your Honor.
Ms. Moore, did that question raise any question for you?
No objection, or no, Your Honor.
Thank you.
Am I free to go?
Corporal, yes.
Good. All
Yeah,
right, thank
I
you,
was just
guys.
gonna say, you're free to go. Thank you.
All right, appreciate it. Thank you, guys. Have a good day.
Thank you, you too.
You too. Ms. Moore, your next witness.
Yes, Your Honor. At this time, people call a phlebotomist Shanique Taplin.
I'll bring Ms. Taplin in. I was hoping someone could tell me if Carrier was going to be a hold.
Would you like me to go check with APA Curry?
No, I don't want you to go anywhere. I was hoping that somebody would drift back into the courtroom. Ms. Taplin,
Yes.
we're ready for your testimony, ma'am.
Okay. Here I am.
If you raise your right hand for me, please. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Ms.
You're
Moore.
welcome.
Thank you, Your Honor. Please state and spell your name for the record.
It's Shanique Taplin, SHANIQUE TAPLIN.
Are you currently employed?
Yes.
Where are you employed?
Beaumont and Royal Oak. I'm a phlebotomist for the nursing homes.
And how long have you been a phlebotomist for the nursing homes?
Since March 22nd of 2021.
Did you receive any special training to become a phlebotomist?
I went to school, phlebotomy school back in 2018.
Okay. Which phlebotomy school did you go to?
It was phlebotomy training specialist in Southfield.
And how long was that program?
It was a month program. I started, I believe, in March.
Are you certified as a phlebotomist?
Yes. I have a certificate and everything.
Have you testified in court before as a phlebotomist?
No.
Have you been called to testify in court before as a phlebotomist?
No.
Were you working on November 3rd of 2019?
I was working at Beaumont Wayne in the emergency room. I was their lab tech.
At that time, were you certified as a phlebotomist?
Yes.
And on that day, did something occur that brings you to court today?
Yes.
What was that?
It was I did a police blood draw. I did a blood draw for the police.
Do you recall approximately what time of day you did that blood draw?
I don't even remember.
But at some point, a police officer came in requesting a blood draw.
Yes.
Okay. Have you taken blood draws in the past for the police?
Yes.
Okay. What does that process look like?
The police come with the, I don't want to say patient, but with the person, and they give us a box, and the box is sealed, and inside the box, I have to open it up, and there's 2 vials with, it's like a powder substance, and there is some paperwork that I have to fill out, and the police officer has to fill out. And then what I get from my container is just everything that I need to draw the blood, which is like a tourniquet, a sealed container, and a needle. And then I just draw the blood, and then I put it in the bag. I label it, I put it in the bag, I seal it back up, and I put my initials on the box, and I give it back to the officer.
When this process occurs, did the officer remain in the room with you?
Yes, the whole time.
And is that standard procedure?
Yes.
Now, on this particular day, did you follow that procedure?
Yes.
Okay, please walk the court through exactly what happened after your initial contact with the officer.
The officer brought me the the person to draw his blood, and we sat him down in the. It's like a second waiting room that's empty, and we sat him down. He handed me the box, and I opened the box. I filled out the paperwork that I needed to fill out, and then I gave it to the officer, so he could fill out the paperwork that he needed to fill out. And while he was filling out the paperwork, I was gathering my items that I needed to draw his blood. And then once the officer finished his paperwork, I drew the blood while he was watching. And then I labeled this specimens, the vials. I put them in the bag with the paperwork, and I put it back in the box.
Okay, hold on. I'm going to back you up for 1 second. So you said that there was an officer there and another individual. Would you recognize that individual if you saw them today?
I honestly don't think I would. It was a long time ago, and I see many people, so I probably wouldn't recognize the person.
Do you remember do you remember a general description of him, or do you have no memory of this individual?
I have no memory. No, I don't have no memory.
Do you recall if anyone else was in the room with you?
No, I believe it was just me, the officer, and the individual.
After you filled out your paperwork, you said that you were actually the one to open the kit. Is that correct?
Yes, we opened the kit, we sealed the kit, and then we put our initials where we sealed it.
And at that point, you then draw this individual's blood?
Yes.
Please just go through a brief summary of how you did that blood draw.
Okay, so inside the box, there's the 2 vials, and there's an iodine kit. And then what we get from our cart is the tourniquet, the sealed back container, and needle, and gauze and a paper tape that we seal it. I opened up the iodine packet. I put it on the site where I was going to draw his blood for about 30 seconds. I let it dry, and then I did the venipuncture, got the blood, put the tape and the gauze back on there, and I labeled the vials.
And how many vials were there?
2. So we fill it up to where it's a label on the vial, so we try to fill it up to the label to make sure that it's enough.
And as part of that paperwork, is it your responsibility to fill out who this individual's name or what this individual's name is?
No, I believe the officer does that. It was a long time ago. I don't really remember, but I know I fill out my name. I fill out the date, the time. Yeah, I believe that's it.
Were there any problems with drawing this individual's blood on this particular day?
No.
After you drew the blood vials, what, if anything, happened with that kit?
What do you mean?
So after you drew the blood, did you hand it over to the officer?
I put the labels on there. I put everything in the bag. I sealed the box, and that's when I handed it to the officer.
What do you seal the box with?
They have a label in the box, and I put the label by the crease where you open the box up. I put it over the crease, and I just signed my initials on it.
And you said that you handed that over to the officer?
Yes.
Did you do anything else related to this case and this individual?
No.
No further questions at this time.
Thank you. Ms. Belcher.
Yes, Your Honor, thank you. Good afternoon, Ms. Kaplan.
Good afternoon.
If I ask you any questions and you don't understand, please let me know and I'll rephrase, okay?
Okay.
It should be very quick. When you first received the box, was the box sealed?
Yes.
And where was the seal located?
Kind of like on the side, but at the bottom. It's like a box that has that crease. It's like over that crease, so we have to I cut it with some scissors and I opened it up.
So there was no indication to you that the seal had previously been broken?
No.
Okay. And then when you put the vials back into the box, you sealed the box yourself?
Yes.
And where did you put your seal?
At the same spot where it was previously open, but it was with the new label.
Okay. No further questions, Your Honor.
Thank you. Any redirect, Ms. Moore?
No redirect, Your Honor.
Ms. Taplin, thank you for logging on this afternoon. You are free to go.
Thank you.
At this time, people call forensic scientist Samantha Kellogg.
Ma'am, would you state and spell your name for me, please?
Yes, my name is Samantha Kellogg, Samantha Kellogg.
Please raise your right hand. Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you much. Ms. Moore.
Thank you, Your Honor. Please restate your name for the record.
My name is Samantha Kellogg.
Are you currently employed?
Yes.
Where are you currently employed?
I am employed by the Michigan State Police Forensic Laboratory in Lansing.
In what capacity are you employed with the Michigan State Police Forensic Laboratory?
I am a forensic scientist in the toxicology unit.
How long have you been a forensic scientist in the toxicology unit?
6 years.
Did you work as a forensic scientist in another unit or for another organization prior to this?
Prior to this, I did work as a forensic technician in my same unit, but before that, I had been in school.
Where did you go to school?
I attended Alma College and earned a Bachelor of Science in Chemistry and Mathematics, and then I went on to the University of Illinois at Chicago, where I earned my Master of Science in Forensic Science.
Do you have any other degrees or certificates?
No.
Were you working as your role as a forensic scientist on, one moment, November 12th of 2019?
Yes.
And on that day, did something occur that brings you to court today?
Yes, it did.
What was that?
A kit was received into our laboratory regarding the defendant.
Now, without talking about the specifics of today, I want to establish a baseline for your procedure. When a kit arrives at your facility, what is the procedure that you follow?
First, one of our forensic technicians gathers all of the kits that have come in that day. Some come in through the mail, others are hand delivered, and they open each one at a time. They log all of the evidence into our computer system and assign each case a laboratory number, and it is then sent for alcohol testing. And after the alcohol testing, if any drug testing was requested, it would then go on for a screen. And if anything were positive there, it would go on for a drug confirmation.
Now, when the kit is initially received, what types of information are logged as far as your lab is concerned?
They log in the agency it was received from, the officer, the agency's incident number, what types of evidence we receive, and how much blood or urine is in those items. And they also enter the defendant's name as found on the blood tubes in the paperwork.
Does all of that information subsequently make it into a lab report that you complete?
Yes, it does.
And if this is standard policy, what role do you have in this process?
So it depends on the individual case. When I was a technician, my role was logging in these kits as I've described. However, now that I'm a scientist, unless there's a really unusual circumstance, I don't do that part anymore. But I do data processing, or sometimes the sample prep and data processing for alcohol testing, and I also do confirmatory drug testing.
Have you received any training on alcohol and how it affects the body?
Yes, I have.
Have you received any training on controlled substances or certain drugs and how they affect the body?
Yes, I have.
Where did you receive that training?
I have received some of it as in-house training in order to be allowed to do those types of testing. However, I have also attended outside training courses, the Borkenstein drug and alcohol courses, and we do continuing education and attend conferences to get the most up-to-date information on those things as well.
Have you testified as a forensic scientist in the past?
Yes.
Have you testified specifically to the lab results and what you have conducted?
Yes, I have.
Have you also testified to the effects that alcohol or particular drugs may have on the body generally?
Yes.
Are there limitations to what you can testify to?
Yes, there are.
And what are those limitations?
I am never able to say what a particular amount of a substance would have on any particular individual, or if an individual was in fact experiencing the effects that a drug or the alcohol can cause.
Are you able to testify to generally how a certain substance may affect a person?
Yes.
Are you also able to testify to what your general values are when you test for these substances?
Yes.
At this time, Your Honor, pursuant to Michigan Rule of Evidence 702, I move to have this witness admitted as an expert in forensic science.
No
Ms.
objection.
Belcher, thank you.
Now, Ms. Kellogg, moving on to the specifics of this case and drawing your attention back to November 12th of 2019, you indicated that you received a kit. Is that correct?
I did not personally receive it, but yes, it was received into our laboratory on that date.
At what point did you come in contact with any of these substances?
I came into contact with this after it had been tested for alcohol and received a preliminary drug screen. I believe the date was December 9th that I did confirmatory testing for cannabinoids.
So I apologize. So the date that we would be, that you came into contact with this was December 9th of 2019. Is that correct?
I believe so, yes.
I apologize. So on December 9th, how did you come in contact with any substance?
So what happens is when I am ready to do a batch of drug testing, I will ask our technicians to prepare a list of cases for me to test. And this one happened to be one of the ones that was up for that day. It just goes by lab number and if there's rush requests, that type of thing. So this was in the batch that I extracted and ran on December 9th.
When you extracted it, did you confirm any of the personal information of where this had come from?
Yes, each time I do any type of testing, I do confirm the lab number that has been assigned to the case as well as the defendant's name with the blood tubes that I'm using and what was entered in the computer system.
Would you have recorded all of that information on a subsequent lab report?
Yes.
So after you received this particular substance, what, if anything, did you do?
When I test for cannabinoids specifically, I remove the tubes from our lockable walk-in coolers, and I do the check as I described to you for the name and the lab number. And then I prepare the samples by removing a small portion of the blood from the tube and then treating it with various chemicals in order to remove any proteins in the blood, anything that would not be a drug of interest. And then after the sample is all cleaned up in that manner, then I run it on an instrument known as a gas chromatograph mass spectrometer. And this allows for first the separation of all of the chemicals in a given sample and then the identification of them.
Is that what you did in this particular case?
Yes, it is.
Was there a particular substance that you were looking for?
Yes, I was looking for cannabinoids, and the cannabinoids that we confirm are THC and carboxy-THC.
Is there a more common name for cannabinoids, THC or carboxy-THC?
Yes, cannabinoids are primarily the compounds that are found in the cannabis plant. THC is the primary psychoactive chemical found in marijuana, and carboxy-THC is its inactive metabolite.
In running your tests through the gas chromatograph mass spectrometer, did anything come up that was unusual?
No, there was nothing unusual in this case.
Is this a reliable method that you frequently use?
Yes.
Do you have any reason to believe that any results in this case would have been untrustworthy?
No, I have no reason to suspect anything was out of the ordinary.
After performing this test, did you receive any results?
Yes.
Did you record those results in any sort of lab report?
Yes, I did.
Would you recognize that lab report if you saw it today?
Yes.
At this point, the people will attempt to share their screen. I'm not sure if I am granted permission to do that.
You should have it.
Okay. Then give me 1 second. Can this be seen?
Yes, ma'am.
Does it look like a lab report, just to confirm, to make sure that that's what everyone is seeing?
Yes,
Yes,
there's
ma'am.
something else on, yep.
Okay. Hold on 1 second. Let me just make sure that nothing else is showing through. Okay, so we're able to see this. And for the record, I would have shown this to defense counsel prior to doing this, but given the nature of Zoom, I do believe I chatted to her what potential exhibits would be shown. So, Ms. Kellogg, are you able to see the screen?
Yes, I can.
And for the record, this is a portion of a 2-page document. Ms. Kellogg, do you recognize this?
Yes, this is the laboratory report that I prepared in this case.
Does this look like a fair and accurate copy of the lab report that you reviewed in this case?
I believe so. If you could zoom in on the results, I would be able to tell you for sure, but.
Are you able to see that better?
Yes, that's
The
correct.
second page, just for record confirmation.
Yes, that is the second page of the lab report with my signature on it.
And you said that this appears to be a fair and accurate copy?
Yes.
Does it appear to have been altered or tampered in any way?
No, not that I can tell.
At this time, Your Honor, people move to admit People's Proposed Exhibit 1 into evidence.
No objection.
It's admitted.
Now, I'm going to zoom in, so if you can't see it, let me know. Ms. Kellogg, right up here, do you see the words that say State of Michigan Department of State Police?
Yes.
And down here in the subsequent sections, it lists a laboratory number. Is that correct?
Yes.
And an agency number, or I'm sorry, and an agency?
Yes.
Please read for the record the name of the agency.
The agency is the Wayne County Airport Police Department.
And does it list an incident number?
It does.
Please read the incident number.
I'm not able to see it, but I do have a copy with me if I could refer to that.
Yes, you may also
That
refer
works.
to the copy. I just want to confirm for the record, it's the same one that you see on the screen. Is that right?
Yes, the incident number is 32914-19. And that does appear to be the same, yes.
And is there a subject name listed?
Yes, that is Mark Brown.
Is it true that on this report it appears Brown, Mark?
Yes.
Right, just want to confirm. Now, it indicates certain evidence that was received. What does the report specifically state?
It states that we received the container that the evidence came in, which is a small cardboard box, and that we received 2 tubes of blood, each with 6 milliliters of blood in them.
And this is consistent with everything that you saw and tested, is that right?
Yes.
Now, down here, the results of the analysis, what does that indicate?
That is the results of my testing, which indicates that I found 27 nanograms per milliliter of THC and greater than 100 nanograms per milliliter of carboxy THC.
Now, just to confirm, what is THC?
THC is the primary psychoactive chemical found in marijuana.
And that's the substance that you were just speaking about a moment ago, isn't that right?
Yes.
Now, you indicated that carboxy THC, which looks like THC-COOH, is not the active ingredient, is that right?
That's correct.
Is THC itself an active ingredient?
Yes.
And turning to the second page, you formally indicated that you signed this, is that right?
Yes, with my electronic signature.
Is this your signature, your electronic signature on page 2?
Yes.
And what does your signature indicate?
It indicates that I am the one that prepared this laboratory report based off the data that I analyzed.
All right. I believe I just stopped sharing my screen. Is that what everyone else can see?
Yes, ma'am.
Now, Ms. Kellogg, a moment ago you indicated that you are aware of general effects that alcohol and other substances may have on the body. I just want to confirm that is what you stated?
Yes.
Is one of the other substances that you are aware of marijuana or THC?
Yes.
Is one of the substances carboxy THC?
Yes, sort of. That's a little different, but yes.
And specifically looking at marijuana or THC, what are the general effects that can have on a person's body?
In general, it alters a person's sense of space and time. So time may be passing more quickly or slowly than they believe. They may be closer or further away from objects than they perceive. And as far as driving, it can cause swerving within the lane, crossing the center line, and increase difficulty with divided attention tasks, such as maintaining lane position and changing the radio at the same time.
But just to confirm, you cannot speak on behalf of what a specific individual was experiencing given their levels. Is that right?
That's correct. I can just say in general, it's possible that it did have these effects, but I don't know in any certain case if it did.
That said, are there standard levels that your test shows?
We test from 1 nanogram to 50 nanograms of THC and 2 nanograms to 100 nanograms of carboxy THC. Yes.
So specific to THC, are there standard or common levels that you see in your lab?
The majority of our cases are in the 1 to 10 range. I would say our average is probably 7 or 8.
And what was the THC level in this case?
It was 27.
One moment. All right, Ms. Kellogg, just to confirm, you were not the individual who performed any alcohol testing on this kit, is that correct?
That's correct. I did not do the alcohol on this kit.
Did you do anything other than the lab report that you just testified to a moment ago?
I did not.
Did you send this lab report to anyone?
It was sent automatically through our system after being reviewed by my supervisor, and I believe it was sent to the investigating agency.
No further questions, Your Honor.
Thank you. Ms. Belcher.
Yes, Your Honor, thank you. Good afternoon, Ms. Kellogg.
Good afternoon.
If I at any time confuse you with my questions or you don't understand, please let me know and I'm happy to rephrase, okay?
Okay.
Ms. Moore, can you mute yourself? I'm sorry, I'm getting your keyboard. Thank you. I believe you stated that you've been employed at the Michigan State Police in the forensic lab as a forensic scientist for 6 years, correct?
Yes.
Okay. And you were not the technician that received the kit in this case?
No, I was not.
Do you know who the technician was?
If I may refer to my notes, I have that information.
Yes, please, if that'll help you refresh your memory.
Yes, this kit was received by Brianna Schaefer.
Thank you. So Ms. Schaefer would have been the one who opened the kit and processed the contents, meaning she would have put the numbers on it and attached it to the individuals and the case numbers and all of that, correct?
Yes.
Okay. And I believe at the top of the report that Ms. Moore admitted into evidence, it stated this kit was hand delivered.
Yes.
But it was not hand delivered to you, so that information would have come from somebody else?
That's correct. The hand delivery refers to it being brought in personally to our lab rather than coming through the mail.
Understood. And are you aware of the officer, or do you have any notes indicating the officer that hand delivered this kit?
I do, yes. I have it was submitted by Officer Ray Bucciarelli. I'm not sure if I'm saying that correctly, but that's the information that we have, yes.
Thank you so much. And given your scope of employment, I assume that you are familiar with the report from the Impaired Driving Safety Commission from 2019 that was done by the Michigan State Police?
Yes.
Okay. And I'm going to speak a little bit about that report and some of your experience. Now, marijuana specifically, it has 2 elimination phases. Is that correct?
I believe that's correct. We don't get into that a lot here.
Okay, but from your experience, you're aware that it has a rapid elimination and a long terminal elimination?
Yes.
Okay, and are you aware that based on these elimination phases, that the levels of the THC in the blood can be indicative of exposure, but not a reliable indicator of whether an individual is impaired?
Yes, that's correct.
Okay. And regular users of cannabis respond differently to the same dose of THC, correct?
It's possible. It's very different for each individual.
Okay, and this is due in part to the tolerance phenomenon, right?
Yes.
Okay. And is there, in your opinion, is there strong scientific evidence that would show that tolerance can occur with regular and frequent use of cannabis?
I'm not sure specifically of any research articles, but I know that is something that happens. Yes, there's not anything specific I can refer to though.
Okay, but it does happen for people who frequently use marijuana.
Yes.
So could this cause unimpaired drivers or chronic users whose blood levels are higher in general to maybe be flagged as an impaired driver when they're not necessarily impaired?
I can't really speak to that, as I can't say what any individual's impairment would be.
Okay. And I believe you stated you were familiar with this report from the commission, correct?
Yes.
Okay. So if the report indicated that, would you have reason to believe that the report is truthful in that sense?
I believe the report is accurate, yes.
Okay. And briefly, I want to talk about the threshold for a THC bodily content. And I believe that's on page 15 of this report. I know I sent the report to Ms. Moore. Are you aware, ma'am, that this report recommended against the establishment of a THC threshold for bodily content?
Yes, I am aware of that.
Okay. Your Honor, I have no additional questions for this witness.
Thank you. Ms. Moore.
No redirect, Your Honor.
Thank you. Ms. Kellogg,
Thank
thank
you.
you for zooming in this afternoon. You're free to go. Ms. Moore.
Thank you.
Your Honor, the people have no additional witnesses.
Ms. Belcher.
Your Honor, I would move for a directed verdict for a number of reasons. First, I would establish that the people have not met their chain of custody. We have testimony from the officer that he placed the kit into evidence and then he did not touch it again. We heard from Ms. Kellogg that a different officer who has not testified today or been presented and delivered it to another individual at her lab, so they have not established their chain of custody. And then I can continue on with the impairment if Your Honor would like.
Your Honor, in response to the directed motion, I apologize. In response to the directed verdict motion, I do want to state that the standard for that is to view the facts in the light most favorable to the non-moving party, that is the prosecution in this case. Regarding the chain of custody issue, I do believe that while we do not have the officer who hand-delivered something to the MSP forensic unit lab, I do believe that we have shown adequate chain of custody in this case. We have that the officer was initially present during the blood draw, that it was locked and sealed up, that it was then taken and put in an evidence locker. We know that eventually that kit was received by Michigan State Police in the forensic unit because it clearly lists the defendant's name, the incident report number, and the agency that it came from. I believe our chain of custody has been met, even though we don't have the officer who picked up a kit and placed it there. We have clear reason to believe that the same kit that was taken by the phlebotomist who did testify and the corporal who did testify was received and tested by the forensic scientist who did testify.
Ms. Belcher?
Yes, Your Honor, thank you. I would respectfully disagree with Ms. Moore. I think that the defense is supposed to be given an adequate opportunity to question all of the witnesses. There are witnesses that have not been presented that have touched the blood kit that contained my client's blood. I think that in order to establish that it hasn't been tampered with and it's been transported properly, we should have an opportunity to ensure that the kit had the sticker on it. There's a reason why that they require these stickers in these procedures, Your Honor. It's to make sure nothing's been tampered with. And quite frankly, in this case, we don't know that. We don't know what happened with the kit after the officer placed it in evidence. And we don't know what, as far as the transport, who received it, the person who opened the kit, which is I would argue, a vital person. I mean, they are the person who is removing the seal and can speak to the condition of the kit. We haven't been presented with any of that, Your Honor.
Your Honor, I would like to note that the lab report that has been admitted into evidence, and I can provide a hard copy as I'm just a room away from you, Judge. The lab report does say in the evidence received, container number one sealed Michigan State Police specimen kit. I believe that is a clear indication that whatever was sealed up by the corporal and the phlebotomist, who again both testified today, arrived at MSP sealed and is the same kit.
And I would disagree with that, Your Honor. We heard testimony from Ms. Kellogg that she did not touch the kit after it was received, that she was working from another person's information, and she gave that person's name.
And yet our lab report, which is based off of that information, indicates that the kit was sealed when it arrived at MSP. And I believe Ms. Belcher's main concern is that another officer hand-delivered it to them. Well, we have information to believe it was hand-delivered and sealed.
It might have been, Your Honor, but the people have not presented the witness who opened the kit or received the kit. Ms. Kellogg testified today that she was working from another laboratory technician's information, and that is what she used to prepare her report. And that's not even getting into the impairment and the lack thereof, Your Honor, that I have an argument for as well.
Anything else, Ms. Belcher?
As far as the chain of custody, Your Honor, no.
Any comment as to count two?
The driving while license suspended, Your Honor, no. I have another argument that I would like to make if Your Honor wants that at this time, or if Your Honor wanted to make a ruling on the chain.
I do, Ms. Belcher.
You do want me to make that, Your Honor?
Yes, please.
Okay, Your Honor, I would point you to People versus Kuhn. That's 494 Mich 1. That information was provided to Ms. Moore. It states, Your Honor, and again, this was a case that was, ruling was established around the time that there was a zero tolerance for marijuana, but I believe the courts have since adopted and used this since the passing of the medical marijuana and marijuana becoming legal in Michigan. It's not enough for a prosecutor to show that a patient has THC in their system. The marijuana must have had a significant effect on the person's mental or physical condition so that she or he, in this case, was no longer able to operate a vehicle in a normal manner. Your Honor, I would just point to the officer's testimony that the reason for the stop was for a non-moving violation. We did not have any testimony from this officer that he viewed my client driving in an abnormal way. He didn't see him swerve, leave his lane. It's simply for a registration plate violation. So I would point to that case, Your Honor, and just say the people have not met their burden.
response, Your Honor?
Yes, please.
While this was initially for a non-moving violation, I do believe that the people have met our burden for demonstrating that the defendant was in fact operating the vehicle while under the influence of a controlled substance. Clearly, alcohol was not at issue here. We are certainly not demonstrating that alcohol was at issue. However, when the corporal went over to speak to the defendant, he immediately noticed the smell of burnt marijuana, bloodshot eyes, and the pupils appeared to be dilated. He then conducted a series of standard field sobriety tests that he went through at length to demonstrate that the defendant was in fact showing impairment. And to be honest, Your Honor, there's evidence to suggest that the defendant even told the officer that on an impairment level of 1 to 10, 10 being the highest, 1 being not impaired, the defendant identified himself to be between a 4 and a 5. Additionally, we have the lab report information that shows that he did have THC in his system. That's the active ingredient of marijuana. And we had a forensic scientist who was very, very clear that she cannot attest to what this individual how this individual was acting and whether or not he was intoxicated. However, she was able to provide some general information about what having active marijuana in your system does. One of the things that she mentions was that it impacted someone's ability to understand time and place, that their ability to move around, to navigate different things. Well, we heard testimony from Corporal Milasor, who, keep in mind, the forensic scientist was not present for that testimony. So any consistencies between those that testimony is an indicia of trustworthiness that this is in fact the case. But Corporal Milasor indicated that the defendant only counted to 3 when he was asked, or opened his eyes after 3 seconds when being asked to close his eyes and count to 30 in his head. And that when the corporal asked why the defendant opened his eyes again after 3 seconds, he indicated he thought that it was 27 seconds. That to me indicates that not only did the defendant say that he felt that he was impaired, but his understanding of time was also affected, consistent with whether or not he was in fact intoxicated by the THC that was present in his system. I believe that that is evidence and proof beyond a reasonable doubt that the defendant was in fact operating his vehicle while intoxicated, and in other words, while under the influence of a controlled substance.
Your Honor, may I briefly respond?
Yes, ma'am.
The case law that I pointed Your Honor to says it's not enough to show, and I believe Ms. Moore's argument is that he has THC in his system and he's operating with this THC in his system. That's simply not enough, Your Honor. And if you look at that case law, they have to also show that they were no longer to operate in a normal manner. There is nothing that has been presented today that shows that this car was not operated in anything abnormal way. I would point out, Your Honor, that you heard testimony from the officer at specifically the questions that I asked him, that there are only 3 tests that are generally recognized by the National Highway Safety Administration as being reliable and admissible in court. And some of the tests that Ms. Moore is bringing up are not those tests. The 3 that are reliable are the HGN, the walk and turn, and the one-legged stand. And quite frankly, Your Honor, the officer wasn't even sure on some of the procedurals that have to be followed in order for these tests to even be reliable. As far as the Ms. Kellogg, Your Honor, you heard her state that regular users of cannabis respond differently to the same dose, so that a level, a number doesn't necessarily show the effects that it's having on that person. She also testified that it's not uncommon for people who are under the influence in experiencing side effects of marijuana to leave their lane of travel, to swerve. They have a difficulty maintaining the lane while turning the radio on. None of that happened in this case, Your Honor. My client was simply stopped. The car was stopped. I won't even say that the officer put my client behind the wheel until he approached the car once it was stopped for a plate that was expired. And with that, Your Honor, I would just renew my motion for a directed verdict.
Motion for a directed verdict denied.
Thank you, Your Honor. Am I able to speak with Mr. Brown in a breakout room briefly to see if he's going to be taking the stand for a defense witness?
Yes, ma'am.
Thank you.
Borgowski? Is that going to be Mr. Curry or Ms. Moore? Mary, oh, shoot, I'm sorry.
I believe that cases, Mr. Curry indicate that the 2 o'clock Anderson Campbell is also dismissal.
Mr. Brown, you should see an invitation to go into breakout room number 1. I'm sorry.
And I was indicating that Mr. Curry has already confirmed that the Anderson Campbell case that was scheduled for 2 o'clock is a dismissal. She should be on.
She is. Get Curry for me, please. Not you. I wasn't waving at you, ma'am. We got behind and it just goes off the rails. Oh, listen, such is life. We've all lived it. No worries. 210147 FY. This is State of Michigan versus Lamarcus Antoine Anderson Campbell.
Alex Curry on behalf of the people, Your Honor, PA 4950.
Good afternoon, Your Honor. Neighborhood Defender Service by Natalie Phelps, P number 83355. Appearing on behalf of Anderson Campbell. Also present via Zoom.
But I know I took.
Anderson Campbell, can you please state your name?
Could you turn that screen on for me, please?
Lamarcus,
Ma'am, would you state your name for me, please?
Lamarcus Anderson Campbell.
This matter was scheduled for a live exam at 2 p.m. today. I've received indication from the attorneys that this matter will not be proceeding. Mr. Curry.
That's correct, Your Honor. I spoke to the OIC this morning. I have another officer here on this matter that our necessary witness cannot be accounted for. The officers, it's my understanding, made multiple efforts to reach this individual through phone calls, but to no avail, Judge. People are not ready to proceed on this matter.
Your Honor, the defense will for dismissal.
Motion granted. Matter will be dismissed.
Thank you, Your Honor.
Anything else, Mr. Curry?
Nothing in this matter, Judge.
Anything else, Ms. Phelps?
Nothing further, Your Honor.
Thank you. We're all set. Have a good day. Ms. Anderson Campbell, thank you for joining us.
Thank you.
Thank you, Your Honor.
You're welcome.
Judge, we have a waiver on the carrier matter.
Bring him in, please. This is 210050 FY, State of Michigan versus Jean Leroy Carrier Jr.
Good afternoon, Your Honor. Alexander Curry on behalf of the people, PA 4950.
Good afternoon, Judge. Good to see you. Scott Wenger, P4587 on behalf of Mr. Carey. United States for a preliminary exam of this matter with Dr. Frost, and we decided to waive the exam. Explain that to my client to understand that he had a right to call witnesses and to have them testify.
Mr. Curry, you're able to hear comments made by your attorney just now?
Yes.
You understand you have an absolute right to have a preliminary examination in this matter where the prosecutor would have to prove that both a crime had been committed, that probable cause existed to believe that you were involved in the commission of that crime.
Yes.
You've had adequate time to talk to your attorney about the rights you'd be giving up by executing a waiver in this matter.
Yes.
And you'd like to waive your right to have an exam.
Yes, ma'am.
You're doing so freely and voluntarily.
Yes, ma'am.
You haven't been threatened in any way, promised anything to get you to waive the exam?
Anybody threaten me? Oh, no.
That does not work. There's an awful little slide over here. It does not meant to go uphill. I've received a signed waiver back from the defendant and his attorney. The court will sign the same. Mr. Carey, you will be now bound over to the Frank Murphy Hall of Justice for the next step in these proceedings, which will be the arraignment on the information on July 21st, 2021 at 9 a.m. Your previously entered bond with any conditions will continue. Anything else in this matter, Mr. Curry?
Nothing from the people, Your Honor.
Anything else, Mr. Weinberg?
Judge, you said the 21st?
I said the 21st, but I don't know that they're actually going in the 2 weeks that they had traditionally gone.
We don't get anything else in the mail.
Once it leaves here, I'm not sure what happens, sir, in all honesty.
Thank you, Judge. We're all set.
Okay, thank you very much. Have a good afternoon,
In your honor, if I may.
if you may.
Ms. Phelps has another matter set at 2:30, right, 2:30. But a similar situation to her other client where the OIC was not able to get in touch with it's a Zoom exam, the Maurice Taylor matter. I can call the OIC and see if we could get that dismissal out of the way now, if your honor would prefer.
It's Maurice Turner and Ms. Belcher's back in. If it's gonna be a dismissal, you go figure that out, that's fine. I'm
Yes,
gonna
Judge.
resume my 12:30 trial.
Oh, Eric Thorpe, excuse me. Yes, Eric Thorpe is,
It's Eric Thorpe and Maurice Turner.
Yes.
Oh, I'm giving away somebody else's case, I'm sorry.
yes, Judge, sorry, Ms. Phelps' other client is Eric Thorpe. And I talked to the OIC this morning, who indicated to me, I don't know if she's here, but she also indicated to me this morning that they were not able to get in touch with the complaining witness. So if if Detective Williams is not out there, I would imagine I would be able to go forward and accept it and move for dismissal, Judge.
Oh, okay.
Yeah, so if I could go check.
Yes, please. Ms. Belcher.
Defense is ready, Your Honor. We'll be calling Mr. Mark Brown to the stand.
I'm sorry. Mr. Brown, would you raise your right hand for me, please? Do you swear from the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
You're welcome.
Ms. Belcher.
Thank you. Mr. Brown, will you state your full name and spell your last name for the record?
Mike Anthony Brown, M-A-R-K, last name Brown, B-R-W-N.
And how old are you, sir?
53.
And sir, can you describe your overall health for the court?
Well, being 53, I had a pass. Yes, we all had pass, but I have a bullet in my back close to my spine.
Okay, Mr. Brown, I'm going to stop you right there. When were you shot, sir?
Back in 99.
And have you been prescribed something for that?
Yes, pain pills.
Have you been prescribed anything else?
Yeah, my marijuana.
Okay, sir. And how long have you used marijuana?
Over the years now.
How many years would you?
I'd say maybe 20, 25.
And how often do you use the marijuana, sir?
Every day, all day.
Multiple times per day?
Yes, because there's a lot of pain in my back and my legs.
Okay. And does this condition, sir, affect your ability to walk at all?
Sometimes, yes.
Okay. And what impairments does it cause you?
I had surgery on my knee, so I have a lot of fluid in my knee, so it's hard for me to just constantly just stand on my feet, on my leg. I can't do that.
Okay. And do you ever use anything to assist you with walking?
Yeah.
You're muffled, Mr. Brown. I'm going to need you to speak very clearly into your speaker, okay?
Yes, I'm kind of deaf in one ear.
Okay, sorry, Mr. Brown. I'll try to speak more clearly.
Yes, ma'am.
What do you use for walking assistance? I believe you indicated there was something.
My cane.
Okay. And Mr. Brown, I want to take your attention back to November 3rd, 2019. Do you remember that date?
Yes, ma'am.
Where were you traveling to on that date?
Well, we were traveling to Detroit, Michigan from Battle Creek.
Mr. Brown, who's we?
Me and a friend of mine. It was me, her, it was a white girl, her child, and her boyfriend. I don't have a license. I was going to Detroit that day.
Mr. Brown, where were you positioned in the car, sir?
Back seat.
Okay. And where were you traveling to?
Detroit Airport.
And why were you going there?
To pick up my brother.
Okay. And at some point you arrive at the airport?
Yes.
And what happens once you arrive, sir?
The flight didn't turn down. The flight didn't come in yet. So we had to sit there for maybe, I don't know, 10 or 15 minutes. So we all got out of the vehicle. I got out of the back seat, which her son was in the back seat with me. Her boyfriend was on the passenger side in the front, and she was driving. We got to Detroit airport. We all got out, stretched the legs. My phone was ringing. I went on the driver's side of my vehicle because it's my car. Answered my phone with the driver door open. Officer pulled up and honked the horn. I told her to move the vehicle. He said, no, don't move the vehicle. The license plate expired, something like that. And we went from there.
Okay, and at some point, sir, I believe you have a conversation with this officer about the substances you use.
Yes.
And what did you inform him of, sir?
My condition of my health.
And what did you tell the officer?
That I agree with everything he said, but I just didn't really understood what he was saying. But I did do what he told me to do.
Okay, and part of your lack of understanding is due to your deafness?
Yes.
Did you ever inform the officer that you were hard at hearing?
Yes.
Did you inform him about the difficulty you had walking?
Yes.
Did you inform him that you needed your cane?
Yes.
Had you smoked marijuana that day, sir?
No, ma'am.
When was the last time that you'd smoked?
Maybe, to be honest with you, from my heart, it was probably like, I don't know, maybe 12, 1 o'clock at night. And I went home, went to bed. I had to get up early to go to Detroit to pick up my brother from the airport. So it wasn't no smoking that day. So he pretty much.
You didn't smoke in the car?
No, ma'am.
Okay. I have no further questions, Your Honor.
Ms. Moore.
Thank you, Your Honor. Sir, I'm going to ask you a series of questions. If you don't understand what I'm saying, let me know. If you can't hear me, let me know, okay?
Yes, ma'am.
Okay. So it's your testimony today that you do have a medical marijuana card, correct?
Yes, ma'am.
And it's your testimony today that you did not smoke marijuana in the morning hours of November 3rd of 2019. Is that right?
Not at all.
A mischaracterization of his testimony. He testified he smoked maybe 1 o'clock in the morning, which would be the early morning hours that day.
Fair. So thank you, defense counsel. So it is your testimony that within 24 hours of when the officer had contact with you, you had smoked marijuana. Is that right?
Yes.
You were present while the officer testified, isn't that right?
Yes.
And you heard him say that he approached the driver, correct?
Yes, but I was in the driver's seat.
Sir, I'm going to ask you to stick to my questions. You heard him say that he approached the driver, right?
Yes.
And you were in the driver's seat when he approached?
Yes, on my phone.
Now, when he approached, he asked you if you had smoked marijuana recently, and you told him that you had. Is that right?
He asked me, was there any marijuana in the car? And I said, no, sir. And he said, when was the last time you smoked marijuana? I said, maybe 2 or 3 o'clock in the morning. That's what I told him. And go ahead.
And at that point, he asked you to step out of the car and go over and speak with him. Is that right?
Correct.
And you agreed to do that, right?
Correct.
And he had you perform a series of tests. There were quite a few of them. Isn't that right?
Correct.
And before he had you do each test, he gave you instructions on what to do.
Yes, ma'am.
And he asked you some questions initially, including you did have an opportunity to tell him about your knee pain. Is that right?
Yes, ma'am.
And yet you continued to do the test that he asked you to do.
Yes, ma'am.
And at one point, he asked you on a scale of 1 to 10 how impaired you were. Isn't that right?
No, ma'am.
It's your testimony today that he never asked you that.
No, ma'am. That's why I was waiting to talk to the judge to see if I can talk, because everything he said is a lie, and he don't remember half of the things that he did, and he didn't do half of the things that he said he did.
Well, but that's your opinion off of today, isn't that right?
No, that's his opinion, the way he sat there and told a lie.
But he did approach you while you were seated in the driver's seat, correct?
No, he said he approached the vehicle while it was moving. The vehicle wasn't never moving when he approached the vehicle.
Sir, it's your testimony that he did approach you while you were in the driver's seat, right?
Your Honor, I'm going to back to asked and answered. She asked us initially, my client confirmed he was seated in the driver's seat on his phone. I think that's been established.
I'll move on. It is your testimony that you completed a significant number of tests in this case, right?
3.
And you also completed a preliminary breath test, which means that you blew into something. Is that right?
Correct.
And he did read you certain rights off of a piece of paper, correct?
Correct.
And he did transport you himself to the hospital, correct?
Correct.
And you did have to go through a blood draw, is that correct?
Yes, ma'am.
And you did not have a valid license, is that right?
No, ma'am, and I wasn't driving.
No further questions, Your Honor.
No additional questions from the defense, Your Honor.
Thank you. Thank you for your testimony, Mr. Brown. Any other witnesses, Ms. Belcher?
No, Your Honor.
Closing, Ms. Moore.
Yes, Your Honor. At this time, the people ask the court for a guilty verdict on both counts. The first one is the amended count 1 of operating while under the influence of a controlled substance, and the second one is driving while license not valid. At this time, the court has heard the testimony from 3 different witnesses for the people and also the defendant. I do believe that there is sufficient reason to believe that Corporal Milasor's testimony is credible, despite the fact that the defendant indicated that Corporal was lying. He did go through many different points. He went through all of the different ways in which he administered the test and all of his observations. I do believe that those are indicative of what defense counsel would have received via discovery. And I do believe he indicated times when the defendant was consenting to certain things. One of them was the consent to do the test, the consent to the preliminary breath test, the consent to the blood draw, even after being read his rights. I also believe that the questions that the corporal asked the defendant of how impaired are you from a level of 1 to 10, with the defendant indicating himself that it was a 4 or 5, I believe that there's an indicia of trustworthiness based on all of that, especially since Corporal Milasor indicated when he was going through with the court all of the tests that he did, he freely admitted that the horizontal gaze nystagmus did not show any indicators of intoxication. I believe that when we have witnesses who are able to identify things that do show intoxication and don't show intoxication, that shows a level of trustworthiness in their testimony. That said, between Corporal Milasor's testimony and the testimony of the forensic scientist, I believe that there are clear indicators not only that the defendant had THC in his system on that day, but that the THC was in fact impairing him. I also believe that despite the defendant's testimony, there are clear indicators to believe that he was operating the vehicle as he was in the driver's seat, and it was his, it was his vehicle as he just stated. As for count 2, it is clear that he did not have a license. The defendant admitted it himself. I reserve further argument for rebuttal.
Ms. Belcher.
Thank you, Your Honor. And I know I made a lengthy argument for the directed verdict, so I don't want to belabor the point. So I'll try to be quick. I know Your Honor is paying attention to everything that we're saying. A couple of things that I would just like to point out again, Your Honor. I don't think that Mr. Brown has indicated in any way that his testimony was not truthful. He's been very forthcoming with all of his responses and has been responsive to everything that Ms. Moore and myself has asked. He indicates that he was not the driver of the vehicle. I think that's corroborated for his story at least to be true, given the fact that when I questioned the officer, he did state that there was a portion of time that he lost sight of the vehicle. I believe that the officer testified he's seen the vehicle pass. He did not identify, from my recollection and my notes, my client to be the driver until he made contact with the car once it was already stopped. Then moving to the impairment, Your Honor, I again would renew all of my previous arguments pointing to People v. Kuhn. I know I previously cited that. I don't believe that people have proven beyond a reasonable doubt that my client had an his ability to drive was impaired. And I'm not admitting that he was driving. Let me be very clear about that. They have to show that the marijuana was not just in the system. We had testimony from Ms. Kellogg, and she did state, Your Honor, that it is not uncommon for regular users of cannabis to respond differently to the same dose, that tolerance occurs, that can inappropriately flag unimpaired drivers or chronic users whose blood levels are higher or higher in general as being impaired, that the report prepared by the Michigan State Police and the Safety Commission in 2019 recommended against the establishment of a threshold of THC bodily content. And again, Your Honor, I would renew all of my same arguments about the chain of custody. I don't think the people have presented the proper witnesses to establish that this blood was not tampered with. I think in order to establish chain of custody, you need every piece of the puzzle to show who has put their hands on the kit. As far as what Ms. Moore brought up about the horizontal stigmas test, she stated that the officer is credible because he said that this test did not show any impairment. That's simply not true. He then turned around and said that because there was no nystagmus present, that is common with marijuana users and the relaxation of the muscles of the eye. So I don't necessarily think he's saying that my client passed that test for marijuana use. So I don't think that goes to Ms. Moore's point. But I would renew all of my same arguments, Your Honor. I don't think the people have met their burden.
Ms. Moore.
Yes, Your Honor. I believe that there are three main issues from defense counsel. One being that the defendant was not the driver and therefore was not operating in this case. Once again, I stand by Corporal Milasor's testimony that when he approached, this individual was in the driver's seat, that it is in fact his vehicle. Next, I turn to the intoxication issue. At this point, Ms. Belcher and I have gone back and forth on whether or not this individual was in fact intoxicated. I do recognize that habitual marijuana users may build up a tolerance. However, there are clear indications that this individual was intoxicated. It was in his red eyes, his dilated pupils, and the different ways in which he performed the standard field sobriety test and his own indication as of Corporal Milasor. So I believe that the intoxication issue has clearly been established beyond a reasonable doubt. And finally, the chain of custody issue I have already addressed. I believe that there is, once again, indicators of trustworthiness and of the fact that the kit that was taken at the hospital by Corporal Milasor and by the phlebotomist and even by the defendant, all testifying that his blood was drawn, that same kit was the one that Samantha Kellogg tested on the date and time and with which we have the lab report. I move for a guilty verdict should the court find it reasonable given the circumstances.
Thank you both for your arguments this afternoon. The court's had an opportunity to listen to all of the witnesses and will find Mr. Brown guilty to the amended count of operating under the influence of a controlled substance and operating while license not valid. The matter will thereafter be referred to probation. Anything else, Ms. Moore?
Nothing from the people, Judge.
Anything else, Ms. Belcher?
No, Your Honor, thank you.
Thank you. Have a good afternoon. Mr. Curry.
Yes, Judge. We
So
were to do Bargowski?
Bargowski's a hold, right?
Correct, Your Honor.
Okay, and Thorpe's a dismissal.
That is correct, Your Honor.
Okay, let me get the dismissal and then we'll take a brief recess. Brief being super brief. 210150 FY State of Michigan versus Eric Sheldon Thorpe.
Good afternoon, Your Honor. Alex Curry, the people, P84950.
Good afternoon, Your Honor. Neighbor Defender Service by Natalie Phelps, already 55, hearing on behalf of Mr. Eric Thorpe, who is also present in the courtroom, standing to my right. Mr. Thorpe
Sheldon Thorpe.
Thank you. This matter was scheduled for a live exam this afternoon. How are we proceeding?
Judge, if people are not ready to proceed at this time, in a similar breath to our previous case, I spoke to the OIC this morning and just outside. She has not had any luck in contacting our chief complaining witness, and the people aren't ready to proceed, Judge.
Ms. Phelps?
Your Honor, defense would move for a dismissal at this time.
Defense motion granted. The matter will be dismissed. Anything further, Mr. Curry?
No, Judge.
Anything further, Ms. Phelps?
Yes, just briefly, Your Honor, Mr. Thorpe's weapons were confiscated during this case. If we could have the police department, the Rollins Police Department, I believe, still has those guns. If we could have those released to Mr. Thorpe. Is that an order I need to submit to the court?
I was gonna say, I would think so, but if you
Yeah,
could ask and find out.
Yeah, I believe that's an order to Your Honor.
Your Honor, I could have that order to this afternoon.
Thank you.
Thank you, Your Honor.
Mr. Burkhead, I've not seen your client as of yet.
Your Honor, my client is in the office with me.
Oh, boy. Mr. Burkett, unfortunately, we have a exam from noon that has not been held yet. So if you and your client would sit tight, we haven't forgotten about you, okay?
Oh, I know you hadn't.
Thank you, sir. I'm gonna take a brief recess.
Judge, did anybody ever tell you you had a beautiful smile?
Thank you, Mr. Burkett. Do you need to speak to the prosecutor at all this afternoon?
Sure, I'd like to talk with her. Yes.
Tim, could you get Ms. Moore, Mr. Curry back on, and we'll put Mr. Burkett in the breakout room with one of them? Brief, I'll be back in what, not even 3 minutes. Real 3 minutes.
No, you ain't.
So when I said a real 3 minutes, nobody understood what that meant. Ms. Moore?
Hi, Judge.
Hi, Mr. Burkett is here with his client. If I could move you into a breakout room with him.
That would be great, Judge. Thank you.
Thank you. So when I say 3 minutes, what did they hear me say? That everybody's gone. So maybe I should go out in the hallway and see if we can get people back in here. No, hopefully they're talking.
the number out there? You can't hear that phone ring?
No,
When
you're talking about two different things. I was talking about inside, you're talking.
No, I'm talking about the phone out there. What's the number out there?
273.
Oh, yeah, I was so close.
I had to think for a minute which one. That's a penthouse.
Good afternoon, Judge.
Good afternoon.
On the Burkett matter, I believe he should be coming right out of the breakout room. We're looking at a dismissal.
Oh, then let's force him out. Oh, Mr. Burkett, thank you. He's been waiting ever so patiently. 210306 FY, State of Michigan versus Maurice LaShane Turner Jr. Appearances, please.
Good afternoon, Your Honor. Elizabeth Moore on behalf of the people, P84724.
Once again, good afternoon, Your Honor. Raymond Burkett on behalf of Mr. Maurice Turner, and we're in my office, and he's sitting here beside me, and we do not object to this video of that. Say good morning. Have a good afternoon.
Good morning, Your Honor.
Good afternoon. Would you state your name for me, please, sir?
Yes, Maurice Turner.
Thank you.
Your Honor, today is the date and time set for preliminary examination. I have spoken with fellow Assistant Prosecuting Attorney Alex Curry, who has tried to get in contact with the complainants. We've not been able to get a hold of the complainants. We have spoken with the officer in charge, who has also not been able to get a hold of the complainants. We ask that should this court grant a dismissal, it be without prejudice.
Mr. Burkett?
Yes, Your Honor. Understanding that, Your Honor, I would ask this honorable court to dismiss this case.
Defendant's motion to dismiss is granted. The dismissal is without prejudice. Anything else in this matter, Ms. Moore?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Burkett?
No, ma'am. And thank you very much for your
Thank you.
patience.
Thank you for your patience. And I would note for you that your client has some outstanding matters in the court. He owes a total of $1,350 on those unrelated matters.
I will see that we will take care of that, Your Honor. And
I'd
once again,
appreciate that.
sure. After he's paid me, he can pay you. I'm joking.
Have a good afternoon, Mr. Burkett.
You too, Your Honor.
Thank you.
Did he say after he paid me?
He sure did. He sure did. I love it. Oh. No, we'll do it without the prosecutor.
Is this your pile of things going down?
Yes.
I'm just gonna grab them.
Yeah, we gotta talk when we go off, because I have a million. Okay. Two 10391 FY, State of Michigan versus Heather Lynn Rogowski. Appearances, please.
Good afternoon, Your Honor. Alexander Curry on behalf of the people, P84950.
And good afternoon, Your Honor. Tiffany Hahn on behalf of the defendant, P7957.
Your name, please, ma'am.
Heather Lynn Bargowski.
Thank you. This matter is scheduled for preliminary examination this afternoon. How are we proceeding?
We're ready to go, Your Honor.
And the people are ready to proceed, Your Honor.
Mr. Curry, do you have any preliminary matters to be disposed of?
I do not, Your Honor.
Ms. Howe, any preliminary matters that need to be disposed of?
No.
And the people, or may I call my first witness, Judge?
Yes.
Thank you. And the people call Ms. Danielle Heading to the stand.
Telling you.
No, I think it's the OIC in the other case.
Detective Casson?
Yes, Your Honor.
What are you here for, sir?
Maurice Turner.
This is Detective Chasm, this is APA Curry in the courtroom. I had him on to explain if needed, if the court would have liked it, to explain our efforts to locate the complaint witnesses.
Okay. You're free to hang around, but if you were here on the matter was dismissed.
Okay,
Okay,
all right, thank you.
thank you. Ma'am? Hi.
Sorry, my 1-year-old daughter's out there.
You're how old?
1-year-old daughter.
Is somebody out there?
Oh yeah, my brother's.
Oh, okay.
I just left her out there.
I mean,
hang out.
listen, we've seen worse, so. Would you state and spell your name for me, please?
My full name?
Yes.
Danielle Bonita Brochan, DanielleBonitaPetty.
Raise your right hand for me. Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You're gonna come up this ramp and have a seat in this purple chair.
Okay.
You okay? That's what I'm asking. Are you okay?
And Your Honor, I have the officer in charge seated to my right as well. She will not be testifying.
Okay. It's better than the last one. Your witness, Mr. Curry.
Thank you, Judge. Would you please briefly repeat your name for the record?
Danielle Bonita Petty.
And Ms. Petty, I would like to direct your attention to May the 11th of 2021. Where were you that day?
At home.
And what's your address?
22055 Verdun Street, Romulus, Michigan 4811447.
Is that in Wayne County?
Yes.
Thank you, Ms. Petty. And Ms. Petty, what were you doing that day?
I was watching TV.
And what, if anything, occurred while you were watching TV?
Something did occur. I heard a noise on my door.
And upon hearing the noise, what did you do next?
I opened my door to look.
I'm sorry, Ms. Petty, 1 second. When you turn back and forth, the recorder loses you.
Well, which way would you like me to look?
No, it's the microphone. The way you were spinning, you were
mean
turning your
really
face away from the microphone.
Hang out with it like this?
That's good. I'm sorry. There's nothing funny here. It's just been a long day.
I understand.
Mr. Curry.
Thank you, Judge. After you heard that noise, Ms. Petty, what did you do next?
I let my dog out. When you open your front door, your dog thinks they want to go outside. So you let your dog out.
So your dog ran outside?
No, I put my dog on his leash. He has a probably 5 or 6 foot leash that we put him out on every time.
And upon letting your dog out, what, if anything, happened next?
I heard yelling. Lots of yelling.
Where was the yelling coming from?
My neighbor's house.
And was anyone outside that appeared to your observation to be the recipient of that yelling?
Yeah, so my neighbor's back door leads into our yard, and their door was open, and they were standing in that door yelling at my dog.
And are one of your neighbors in the courtroom today?
Yes.
Could you possibly point that person out, maybe by article of clothing they're wearing?
She's wearing a gray jersey t-shirt.
Is she seated to my right?
Yeah.
Judge, may the record reflect the witness as identified the defendant?
Yes, sir.
Thank you, Judge. Ms. Petty, who was the defendant yelling at?
My dog.
And was anyone else at home with you that day?
Yes.
Who was at home?
I reside with my husband and my daughter.
And upon your observation of the defendant yelling at your dog, what did you do next?
Oh, I didn't observe her yelling. I heard her yelling.
Understood. So upon your hearing, but you saw her as well, right?
Yes, I saw her in her backyard.
So upon your observation and hearing her yelling, what did you do then?
I waited for my husband to finish pooping because I wasn't going to deal with that situation.
Understood. And after your husband had finished in the facilities, what did you observe him do anything?
Yeah, he went to go let the dog in.
And what happened when your husband went to let the dog out?
He stopped barking, and then she started screaming at my husband.
And who was she?
My neighbor, yes.
Okay. Could you hear what she was saying?
Not like particularly, no.
Was she cursing?
Yeah.
Was she making any threats?
She said something about me. I don't remember what it was, but after I heard her yelling at my husband, because he's a very passive person, I went out the front door to engage in conversation.
Okay, and when you engaged in conversation, that was with the defendant, correct?
Yes.
And what happened when you engaged in conversation?
She was holding a sword.
She was holding a sword.
She was holding a sword.
How could you tell it was a sword?
It's very distinguished, a sword. She was like holding it and like thrashing it against the floor of her house.
Did the sword appear fake?
No.
How could you tell it wasn't fake?
It made noise, like metal clanging noises against her floor.
So she was hitting the sword against her floor?
Yes.
And it was making metallic noises?
Yes.
And Ms. Petty, was the defendant saying anything while she was holding the sword and whacking against the ground?
Oh, she was saying lots of things. I asked her, I was on the phone with my brother when I went outside, and I asked her why she was holding a sword. And she replied to me, because I'm going to slit your throat.
She said she was going to slit your throat.
Yes.
How many times did she say that?
Once. I only allowed once. I called the police after that.
And Ms. Petty, were you afraid when the defendant was holding the sword?
Yes.
Were you afraid when she was making those threats to you? Or
Yes.
made that, excuse me, that threat to you?
Yes.
And how close were you to the defendant when all this was happening?
So she was in her back door and I was on my front porch. So I wasn't close to her at all. Thank God. Did you want like an exact amount of feet?
No, one moment, Judge, I think I have any questions. Ms. Petty, how close is your residence from the residence?
Ooh, I'd say about 20 feet.
20 feet? And Ms. Petty, I'm sorry, but I am going to ask you for like a rough approximate. How close do you think you were to the, let me rephrase that question. How close do you approximate you were to the defendant when this was transpiring?
22, 24 feet.
No further questions for this witness at this time, Judge.
Thank you. Ms. Howe?
Yes, thank you, Your Honor. Good afternoon, Ms. Petty.
Good
How are you?
afternoon. I'm tired and hungry.
Me too. So first I want to ask you, can you describe your relationship that you have with your neighbor?
I don't have a relationship with my neighbor.
Is it hostile?
I
mean, it is now.
It's like a hard to describe type of situation.
Have you ever had any issues with the defendant before?
I've had issues with the people that mow their lawn.
And this would be a young boy who mows the lawn?
Oh, I'm sorry. You said a young boy?
Yes, it's a young boy.
Yeah, it's a young boy.
Okay. And is it true that on occasions you have yelled at him?
Well, when you try to talk to somebody mowing their lawn, it's really hard to calmly talk to somebody over a lawnmower.
And do you know, does he still mow your neighbor's lawn?
No.
He stopped?
No, he doesn't. Nobody mows their lawn.
I'm sorry?
Nobody mows their lawn.
Okay. And this run-in you had with the person who mows their lawn, did this lead to kind of a aggressive and hostile tension between the two of you?
So it turned into sabotage of my garden, which in turn I had to rip all of my vegetables out of my garden to make sure that I didn't come home to them torn off their vines again.
Okay.
And after that, I just ignored them.
Did you ever have a conversation or any type of communication with your neighbors, either the defendant or her daughter?
No, I try to make my husband take care of those conversations because I'm not a very rational person.
Okay, so just specifically, her daughter never came to your house to ask you why you were yelling at their
She might have.
lawnmower guy?
She came to my door once, and once she started calling me names, I slammed the door in their face.
Okay. And on this particular time, did you then send your husband up, talk to her or say something to her about it?
Yes.
And do you know whether or not he was yelling at her?
I'm so sorry. I can't understand what you're
I'm
saying.
sorry, do you know whether or not he was yelling at her?
No, my husband doesn't yell. Even at me, which is weird.
And your husband, he was there when this incident occurred, right? At the house?
Which one? The one that we're like
Yeah, with the
here
sword,
for?
yeah.
Yeah, he was there.
And what's your husband's name?
David Petty.
And, hold on one second. Nicholas, this is your brother?
It is.
Okay. So you stated that the defendant was yelling at your dog. You sent your husband out there to get the dog. And then her and your husband began arguing.
Nope.
Or yelling at each other.
No.
She was yelling at him.
She was yelling at him.
And then you go outside.
And I started yelling.
Okay. Now, you stated that you were about 20 feet away and she had this sword in her hand.
Yes, she did.
And she was banging on the floor.
Mm-hmm.
She was inside her house.
Yes.
Okay. Did she ever come outside with the sword?
Not the first time we called.
Okay. So, but this particular time, she was 20 feet away inside her house with the sword in her hand. You could clearly see the sword?
Yes.
And you stated that you called the police?
I did. I was on the phone with my brother when she threatened me. I hung up with him immediately and then called the police.
And did you tell the police that your neighbor had just threatened you with a sword?
Yeah.
Was a police report made?
Yes, it was.
Okay, so after the police, so after she's threatening you to slit your throat and banging the sword, you know, what happens after that? Do you then go back into your house?
Yeah, we went inside the house, waited for the police, and she left her house.
Okay. And did you have contact with her again that day?
Yes, we did.
Okay. You went back outside to where she was?
No, my brother did.
Okay. And at any point did you go back outside?
I did.
Okay, and why?
To help my brother.
Help him with what?
I mean, there's a deranged woman outside with a weapon.
So she had the sword outside?
No. But like she did before.
Okay, but this time she was just, what was she doing?
She was in our yard yelling at us, throwing stuff at my trailer.
She was in your yard or her yard?
Our yard.
Because you share yards.
Yeah, so the way that our trailer park works is it's our yard up until one lawnmower length towards, or like from their house, one lawnmower length. So like what, 13 inches, 15 inches?
Okay, but at this point, when she's yelling at your brother, she's on the shared part of the property, the shared part of the yard, not.
No, she's in our yard.
She's on your 13 inches?
No, she's outside of her part of the yard.
Okay, but is she on your yard?
Yes.
Okay. So she's yelling at your brother. Does she have any weapons in her hands?
No.
And so you go outside to help your brother?
Yeah, I stayed on my porch and my brother was in our yard. And he's trying to tell them to get back in their house and just like be done with this tonight. And then they started throwing stuff at my house.
And then what?
I called the police again.
Is that the only contact you had with the defendant?
No, that's not the only contact.
Okay, and what else?
After I called the police, I went out to take pictures of the stuff that they were throwing at our yard. And then I remembered that she left the scene the last time that we called the police. So I went to go and get a picture of her license plate.
Mm-hmm.
I was standing in our yard and my brother said, "Danielle, you need to run." And I look over and she's charging at me.
Okay. And you go outside when she's arguing with your brother, and then you go outside again, take a picture of her license plate, although you were fearful. Because I know earlier you stated that you were fearful when she told you she would slit your throat.
Mm-hmm.
Okay. And what was the reason for getting her license plate?
Because she left the last time the police came.
But doesn't she live next door?
Mm-hmm.
And the police were aware that she lived next door?
Yes.
Okay. So is that the only contact you had with the defendant?
Yes.
Okay. So after your brother tells you to run, you run into the house?
Nope. I stood there and watched her run at me.
Okay, and then what?
He tackled her.
Your brother tackled her?
Mm-hmm.
Okay. Now during this time, when you guys were having this altercation, were you yelling back at her or saying anything back to her?
The second time?
Any time?
Of course.
And was she saying anything to you as she was running towards you?
No, I didn't hear anything at that time.
One second, Your Honor. And is your husband here at court today?
He is not.
Do you know whether or not your brother owns a gun?
If he owns a
Object to
gun?
relevance on that, Judge.
Oh, well, Your Honor, the relevance here would be, according to the police report and my client, the brother told her he would shoot her. So I'm asking a witness who was there.
I'm sorry, I missed.
The brother, Nicholas,
Mm-hmm.
he told my client that he would shoot her. And he pulled a gun out. So I'm asking a witness who was there if she knows whether her brother had a gun that day. I think that's really relevant.
Oh, I'm sorry. I thought you asked, did he own a gun? Did you say, did he have?
I'm sorry, let me revert that. I want to ask, did he have a gun on him that day? And also, does he own a gun?
But to overrule your objection, the question was, does your brother own a gun? Right?
Yes.
Okay. You can answer that question.
No.
He does not?
Nope.
Okay. And did he have a gun on this day?
Nope.
And when you said that the defendant and your brother were outside, was your brother yelling? Do you know whether your brother was yelling? Did you
No,
know?
he was not yelling.
So
He was
she-
telling them just to get back in their house.
And why was he over at your house this day?
Because someone threatened me.
So he came over there specifically for that reason?
Yes.
Okay. Your brother lives nearby?
Not, well, he had just broken up with his girlfriend, so he was staying in Allen Park at the time.
Okay. Okay, 1 second. And do you recall speaking to the police when the police arrived the second time?
Yes.
Do you recall who you spoke to? The actual officer?
No, there were like 5 officers there.
Okay. And you also stated that you saw your brother push the defendant, correct?
Yes.
Or, I'm sorry, you said tackle.
Yes.
And she fell?
Mm-hmm.
I'm sorry, ma'am, you have to say yes or no.
I'm sorry. Yes.
And, okay, I think that's about it. Let me double check 1 second, please. Your brother, when he arrives, does he come into your house first, or you immediately just hear him arguing or being yelled at by the defendant?
He came to our house first. There was no one to argue with. She had left.
Okay, so he then walks outside. How does he come to have contact with her? Is he leaving the house when you say he's outside and they're yelling at each other, or she's yelling at him? If he was in your house originally and she wasn't there, he then walks outside. Is he leaving?
So she had come home about 10 minutes after the cops left, and apparently her daughter and her were flashing my brother through their windows.
While your brother was inside your house?
Yes, while he was inside our house.
And
He also
so-
smokes a vape, so he goes out to the porch to do that because I have kids.
And so at this point, this is when you hear the yelling and you come outside?
Yes.
Okay. Okay, no further questions. Thank you, Your Honor.
Thank you. Mr. Curry?
Yes, Judge, very briefly. Ms. Petty, defense counsel asked you a few questions about your reaction to that, reaction to this event, and you said you're not a rationalist. What do you mean by that?
When someone is threatening my family and my life, motherhood kind of takes over in that situation.
But you never made any threats to the defendant.
No, not at all.
And defense counsel asked you a few questions about how you were feeling at the time, the second time the police were called when you went outside and you were taking pictures of license plate. Were you scared then?
My brother was outside with me, so I felt protected with him around me. But yes, I was still scared.
Were you scared at the time the defendant had the sword?
Yes.
And did you ever threaten the defendant?
To call the police. That's all I've threatened to do, and I fulfilled that threat.
But nothing to ever harm her?
No.
No further questions, or no further questions, Judge.
Thank you. Ms. Petty, thank you for your testimony this afternoon. You may step down.
Thank you.
You're okay. Your next witness.
That's it, Judge. No further witnesses for the people. Yeah, he's here.
If you would, please, Kim. I don't hear it anymore. Good afternoon.
How you doing?
I'm wonderful. How are you?
I'm great.
Would you state and spell your name for me, please?
Nicholas Michael Roshan, last name Rochon.
Mr. Roshan, would you raise your right hand for me, please? You swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
I do.
I appreciate that. Come around to this purple chair. You're going to pull it all the way up to the microphone for me, please. Yes. When your sister got up, she just pushed it way back. You need to come up to the microphone. Ms. Howe.
Thank you. Good afternoon, Mr. Roshan.
How's it going?
I'm good. How are you? Mr. Roshan, can you tell us what brought you to your sister's house on May 11, 2021?
She called me saying somebody.
I'm sorry, Mr. Roshan, you need to pull that microphone closer, scoot up to it. She's not able to pick you up.
Can you hear me now?
Thank you.
My sister called me on Facebook Messenger saying somebody was swinging a sword at her.
Okay.
That's what got me there.
So she called you to tell you that?
Yes.
And she asked you to come over?
No.
And approximately how long after you received that phone call from your sister did you make your way over there?
Probably 5 minutes after she called me, I started my way there. I was at E-Course and Telegraph, so it didn't take but 15 minutes to get there.
Okay. And was your sister, who was at the house with your sister?
Her husband.
And did she go into any other detail? So, I'm sorry. So when you get to the house, do you see the people who she said was swinging a sword at her?
No, when I got there, the police officers were still there taking her statement.
Mhm.
I stayed there till after that, and as soon as they left, as soon as the cops left, 5 minutes later, they pulled in and started yelling at the house, and that was it. I went out to my car to get my coat because it was cold, and they just started screaming out the window and flashing and all that stuff. I was not having it.
You're not having someone yell at you?
What? They were yelling at me through the window, and then when I said, please stop, they opened the back door and jumped out.
Okay, so they were yelling at you from inside their house?
Yes.
So as they were, you said you went to the car to get your coat?
My coat.
So once you got your code, did
I went
you,
back in the house.
okay, so did you exchange any words with them?
Yeah, I probably did. I said, please leave us alone. And that was about it. Because in anger, I'm not supposed to talk when I'm angry. That's my rule.
It's a good rule. Now, Mr. Roshan, did you have a gun on you this day?
I don't own a firearm.
And you also did not have a gun on you?
No, I have no access to one.
Did you have anything in your hands?
A flashlight.
It was dark at this point?
Was that?
It was nighttime?
Yes, it was nighttime.
Did you do anything with that flashlight?
Yeah, I flashed it at him because she kept coming towards me.
So at this point, she is now outside her house?
She jumped out the back door.
Mhm.
And I said, you might not want to do that. She started walking towards me and I pulled a flashlight out of my pocket, said, please stand back.
Okay. Did you ever tell her that you'll shoot her?
Never once.
Okay. Did you push her or tackle her?
Yeah, I did after she went after my sister.
When you say she went after your sister, what do you mean?
I went to my car and I looked back behind me and I see her running down her trailer with fists clenched. And I said, Danielle, run. Danielle didn't move. She stood there and I just walked in front of them, walked between her and Danielle. And that's when she pushed me out of the way. And I was like, nope, get out of here.
But prior to you pushing her, she had not physically.
No, she touched me. She touched me. When I went between her and Danielle, she pushed me out of the way. She tried to.
Okay. No, I'm talking about before you. No. She didn't touch your sister at all, though.
No, I did nothing. Nope. I wouldn't let her.
And do you know what your sister was doing outside during the time when
all this went down?
When you pushed.
Danielle was trying to get her license plate number.
Now you stated that, let's go back, you go to your car to get your jacket.
Yep.
They're yelling outside their house.
Yeah, through the window.
They're yelling at you, yeah. Then they're flashing you too,
Yes,
correct?
both of them. It was very awkward.
Then she jumps out of her back door.
Out the back door.
Okay. And at this point, when she jumps there, where does she land? Is she still?
She was on Danielle's property because there's only this much room and she made a nice.
So as soon as she stepped out of her door, she's on Danielle's property?
Yes.
Is this in shared property?
It's not shared, no. There's a property line.
At any point, do you go onto her property?
No.
At any point, do you go to her front door?
To her front door?
Yes.
No.
At any point, do you have any type of physical contact with her daughter?
Never.
Did you take a bat from her daughter?
I'm going to object to relevance on that, Judge.
Your Honor, I think it's very relevant because according to the witnesses, I'm sorry, the defendant in the police report, a bat was present, a bat was used.
You want me to tell you where she got that bat?
Whatever may have happened after the fact, Judge, when the brother arrived, it is, again, it is, Judge, it is after the fact of the alleged assault made by the defendant on Ms. Petty. So people would object for relevance as to that count of assault, Judge.
Objections overruled.
Did you take a bat from the daughter?
After she hit me with it, yes.
Okay. And when did she hit you with it?
This was right after Danielle was getting the picture of the license plate. I told Danielle to run because I saw the mom running down right next to the trailer towards her with the fist clenched. And I said, Danielle, run. She didn't move, so I started walking that way, got in between them, and she pushed me.
Okay. So the bat, she hit you with the bat after you pushed her mother?
Yes.
Okay. And did you take the bat from her?
I did.
And did you hit her with the bat?
Never.
Okay. And what did you do with the bat after you took it?
I put it in the trunk of Danielle's car.
Okay.
Waited for the police to come because Danielle was already on the phone with the cops when all this went down.
Okay. And did you you spoke to the cops, correct? When the cops arrived, when the police arrived, you spoke to the police?
Yes, I filled out a statement.
Now, during this time, approximately how long were you outside from the time you first got your jacket from the car into this whole?
45 seconds.
Did you see a sword?
I came after that.
Okay, so no?
No.
Where was the husband on this?
On the front porch.
He stayed on the front porch the entire time?
I'm sorry, Mr. Rashad, you actually have to say yes or no.
Yes.
Thank you.
And do you know where the husband is today?
I didn't hear you. What?
Do you know where the husband is today?
He's at work.
Do you know about your sister and her neighbor having any type of disputes or issues prior to this?
Yes. Last year, they had a dispute over the garden.
Okay, no further questions. Thank you.
Thank you. Mr. Curry.
Thank you, Judge. Mr. Rashan, defense counsel asked you a few questions about pushing someone. Who did you push again?
The mother.
Is the person seated to my right?
Yes.
And Mr. Rashan, you pushed her to protect your sister,
Of course.
and you pushed her after she had run out of the house.
Yes. Yes.
And you testified that she had her fists clenched when she was running
Yes.
out of the house?
Running down the house.
Running down the house, excuse me. And actually, that brings me to my next question. You testified that these two properties are separate, correct? They're separated by a property line?
Yes.
How close would you say these two residences are together?
13 feet.
And you testified that you do not own a firearm, correct?
I do not own a firearm.
Did you make any threats involving a firearm that night?
No.
No further questions, Judge.
Thank you. Mr. Roshan, thank you for coming in this afternoon. You are excused. You may step down.
Can I go back to work now?
Yes.
Okay, thank you.
Any other witnesses, Ms. Howe?
No, Your Honor.
Argument, Mr. Curry.
Yes, Judge, I think we move for a line over at this time. I think focusing in on count one for defendant number two, or excuse me, count number two for defendant number two. We had an instance where the dog was let outside. The first witness, Miss Petty, heard yelling. Her husband went outside to get the dog. And then she heard yelling, then she went outside. Then she found herself outside. I believe she testified approximately 20, maybe a little less, 20-ish feet, which is still probably closer than you and I are standing, Judge. To the defendant, having a sword in her hand, making a threat to slit her throat with that sword. She heard that it was a real sword by the metallic banging that the complaining witness heard against the ground, and you testified that, or you the judge, the complaining witness in this instance testified that she is not a rational person in those situations. And I asked her, what do you mean by that? When someone makes a threat against her life, so we can know that at least subjectively the defendant did fear for her life in this instance. Give fear, maybe not for her life, but fear in this instance at the hands of a real sword, Your Honor. So the people would ask for a bind over at this time.
Ms. Howe?
Yes, thank you, Your Honor. First, to count one, there's been no testimony in this record that my client ever made an assault with a dangerous weapon to Mr. Nicholas Rochon. He testified that if.
She's not charged.
Oh, I'm sorry.
Count two solely as to Ms. Petty.
I'm sorry, just to Ms. Petty. Your Honor, in this case, I think this really comes down to two neighbors who just don't like each other, who don't get along. They had a dispute over the garden and grass cutting. I think this has been blown out of, this has been exaggerated. Ms. Petty testified that she sends her dog, that she sends her dog outside, she hears my client yelling at the dog. Not yelling at her, not yelling at anyone else, yelling at the dog. Her husband goes out to retrieve the dog. Then hears her husband getting yelled at, or they're arguing, so she goes outside. She claims that my client had a sword in her hand, but she also stated that my client was inside her home, inside the house, 20 feet away, and she wasn't swinging the sword at her. This alleged sword, she was banging it on her own floor, inside her house. So I don't think there was a real threat to Miss Petty. I don't think Miss Petty truly felt threatened. And we also know that she didn't truly feel threatened because she later goes back outside to engage with my client yet again. This time she's claiming to go outside and take a picture of a car. So in case she pulls off, the police can find her, even though she lives next door. So the police can find her and say exactly where she lives at. You know, she calls her brother up. And Your Honor, if we can recall, her original testimony, she said she was on the phone with her brother. He heard it. He was concerned. When her brother testified, she called him after the alleged sword was being swung at her. Her brother words were, his sister called him saying, "Oh, my neighbor's swinging the sword at me." And that's not what Ms. Petty testified to. So already I think there's quite a bit of evidence here to see that as nice as Ms. Petty seems, she's not very credible. And what she's saying is not aligned with her brother is saying or the police report is saying. So the brother comes over, he claims that he goes outside, his sister said he went outside to smoke, and he said he went outside to get his jacket, and that's when my client and her daughter are flashing them, yelling at them again, and he even said himself, "I'm not taking that." These are two people who are looking for a fight, two agitators, two people who, you know, they were engaging in arguments with my client. Now they're coming out saying, "Oh, I felt threatened, I feel afraid." Miss Petty, none of her behavior indicates any type of fear, any type of fear for her life, for her safety. You know, she also stated that her brother tackled. Miss Petty never testified that she saw my client push Mr. Rochon like he said he was pushed. She just said my client was coming towards her and he tackles her. And when I asked her what did she do when she saw my client running towards her, she said, I stood there. That's not a person who's afraid. The person who was afraid runs. She stood there looking for trouble, looking for altercation, ready for one. She called reinforcement. My client and her teenage daughter, and it's Miss Petty, her adult husband, and her adult brother. And they're out there arguing and they're out there engaging. I don't think that my client did not have a sword. My client not swinging a sword. My client not threatening Miss Petty. And Your Honor, I think it also goes to the fact that the husband is not here. Another witness who would have seen in her my client allegedly swinging his sword or hitting his sword on the floor and threatening her. So I don't think there's enough here. Again, I think these are two neighbors who just do not like each other and arguing with one another and exaggerating here. But I do not think there's enough evidence here to bind my client over. And I understand the standard is a very low one, but it's still a standard, and the people are still required to meet it, and it has not been met here. Thank you.
Mr. Curry.
Yes, Judge. Well, I don't think the fact that, I think even legally, I don't think the fact that the husband isn't here and can't testify today can't be used against our case today. And I think his absence here and what he saw and what he could testify to in and of itself, if we're going to use that in this preliminary examination, like begs a question of fact, Your Honor, as to what he saw, what he heard, and what went down. But what we did hear from Ms. Petty today is, first of all, she testified that she was scared. She'd sworn up and said that she would testify truthfully. And she said she was scared, Your Honor, that I would rest on my previous argument, not rest, but invoke my previous argument again, that she says that she's not a rational person in situations where she's threatened, where that instinct of motherhood kicks in. And furthermore, Judge, she called the police after. I think it's perfectly reasonable to conclude that a person who is in fear in an assaultive situation at that time, Judge, would call the police in that situation. That's exactly what she did. She testified on, I believe it was cross-examination, that she didn't, as soon as the sword was brandished, clanked loudly, she could clearly tell it was a real sword based on the metallic clanks. She went inside and called the police. She didn't engage any further, Judge. That at least, by the standard of probable cause, evinces someone who is in fear, is a reasonable person in fear at that moment, Judge. And finally, Judge, I get in disputes with my neighbors too over arborvitaes and bushes, but I don't ever bring a sword out, let alone another weapon, out to my disputes with my neighbors. Nor do I follow up those disputes with running outside of a house, closed fists at the person who I previously was in that dispute with and held my sword against, Your Honor. And I think we can quell any concerns defense counsel may have about her not being scared about going outside after this incident has occurred, and how a person who was scared previously wouldn't go outside. She said that her brother was there. Her brother was there, and she felt safer. And she even said that she still felt scared at that moment, but she said that she felt safe enough to go outside to further possibly provide evidence to the police. She doesn't know what would be useful to the police at that time. She was trying to gather things to rectify the impetus behind this entire transaction, Judge, which is the defendant brandishing a sword 20 feet, possibly less, from the complaining witness, threatening her, telling her that she was going to slit her throat, and the complaining witness subsequently feeling threatened, going inside, calling the police, and then all this song and dance about what happened after, Judge, I think is an afterthought. It's relevant, as Your Honor ruled, but it is an afterthought to the assault that transpired between the defendant and the complaining witness. So the people would one more time, Judge, ask for a bind over this time.
Of course, had the opportunity to listen to the testimony of both witnesses this afternoon, and will find that the prosecution has met its burden for the purposes of exam, and Ms. Spargowski will be bound over as previously charged on the sole count of assault with a dangerous weapon. The next hearing in this matter will be the arraignment on the information at the Frank Murphy Hall of Justice on July 21st, 2021 at 9 a.m. Ms. Spargowski's bond with any conditions will continue. Anything else, Mr. Curry?
Nothing from the